for the reasons stated above, MFA number 12, 2019, filed by the Union of India Railway is dismissed. MFA 160, 2019, filed by Have they heard? Yes. Connected. Connected? Yes. Dismissed. Case dismissed. I think it's not audible. I have some problem. I think.
Duta appeal asil beleg. My lord, in the MFA 162 2019, Lordship, item number 2, in the item number 2,
the matter would be heard on the judgment would be passed on Monday, madam, in a POXO case.
Criminal revision.
Yes, madam. Unless the judgment, madam, is a state.
Judgment will be passed on Monday.
Yes,
How it will help you? What is this?
Madam, in a POXO case, madam.
Hmm.
So, without determining the age of the victim, the petition which we have filed, and also without hearing the counsel for the accused, madam, the judgment is going to be passed on Monday.
It's the last item.
Your Lordship, I beg to mention item number 20 to 22, Your Lordship.
20?
20, 21, and 22, Your Lordship.
Hearing.
Yes, Your Lordship, with the consent of the parties, Your Lordship. May it be fixed after the puja break, Your Lordship.
Okay. Okay, Mr.
Wairam.
Ram, you are for appellant.
In item number 21, Your Lord.
And item 20 and 21. He is appellant in 22, huh? 20 and 21. With the consent of the Lana Council appearing on behalf of the other side. Praise for listing this matter after the ensuing puja vacation. The prayer is allowed. List this matter after the puja ensuing puja vacation. Okay.
Obliged.
May I please, my lord? My lord, I would like to mention item number 7 with consent from the petitioner, my lord.
Why? You are for?
I'm for the respondent, my lord.
Respondent.
Yes, my lord.
Who is for the petitioner? I was thinking of disposing of this matter.
Actually, my lord, as per instruction by my senior counsel, due to some personal as per instruction by my senior counsel.
Who is your senior?
M. Kato, my lord.
Kata. When do you want?
After break, my lord.
No point keeping this such matter. We'll see. We'll see if it is possible. You are for respondent.
Yes.
But then this is against respondent. There is error. Apparently there is some difficulties here in this case. Need to dispose of. Well, okay, let us see if it can be disposed of in your presence. Since you are here, okay, wait for some time, okay? Yes. Item 9. Yes. After puja vacation. You are for? Okay, have you informed the other side? Yet to appear. So why you are taking adjournment? Service complete? Mr. Land Council for the petitioner. Why you want it? Why you, why are you seeking adjournment? Why Irang Land Council submitted the leading counsel in the case, Mr. Leasing Parme, El Parme, has some personal difficulties today, therefore pray for adjournment of the matter for 2 weeks. The further submits that the respondents are yet to appear in the case. In view of the above, and as prayed for, from at least this matter after 2 weeks. Okay,
May I please, my lord? My lord, I beg to mention item number 8. ma'am.
8.
8. The conducting council is out of station, my lord. So kindly matter may be adjourned for the
What we will do is we'll sit for hearing.
hearing.
This is ready for hearing, I've seen.
Yes,
Okay.
my lord.
You are for?
For
petitioner?
petitioner, my lord.
Appellant,
Appellant, my lord.
okay. The other side also appeared earlier,
Yes, you.
you have obtained.
I have, yes, I have done.
Okay, Mr.
M. Nathan.
Land Council for the petitioner is present. Parties are duly represented and records have also been received. Let the matter. Okay, whether record received in item 8. Let the matter. Be listed for hearing, huh? Record received. Okay, okay. The matter is admitted for hearing, huh? List this matter after 3 weeks.
Oh, my lord, interim is there, that may be counted.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
My lord, I like to mention item number 20 on behalf of D. Tamuk, the leading counsel for the respondent. Due to some personal difficulties, she could not come today. I have taken the consent from the other party. Kindly, the matter may be fixed after puja break.
Okay. You are a Mr.
O Pangam, my name is not listed.
Some is that the leading counsel, Mr. D. Tam. Or it's Mr. or Miss
Miss D. Tamuk.
D. Tamuk, Land Council for the respondent has some personal difficulties today. Therefore, he made a mention for adjournment of the matter. He had also obtained consent from the Land Council of the petitioner. So, in view of the above, and as prayed for, the matter stand adjourned. List this matter after 2 weeks. 2 weeks, 3 weeks
Yeah, after puja break,
Okay.
puja vacation,
after the ensuing puja holiday. Okay.
obliged.
May I please, Your Honor? Your Honor, I beg to mention item number 19.
Nineteen is in order. Let us see the records and we'll pass order. Okay, you are seeking adjournment or what?
Yes, my lord.
Okay, we'll see the record.
I was supposed to take steps, my lord. However,
Wait.
Okay.
You're supposed to take. We'll have to see the records.
yes, my lord.
Okay, because the generally the advocate, we have seen that mentioning without going through the records. And then some, later on we come to know that some order was to be passed, some other order has already been passed, okay? Okay. Hmm. That- 24 is hearing. Yes, what, why? Before the appellant? Okay, Mr. Baum. Lana Council submits that the leading counsel is out of station, therefore pray for adjournment of the matter. Who would be also inform the Lana Council of the other side. Is prayed for comma, list this matter after 3 weeks.
Item number 1.
May I please, my lord?
Yeah.
May I please?
Yes,
Lordship, this is a joint application for quashing of the charge sheet filed by husband and wife, my lord, petitioner, sir, on the strength of the mutual settlement entered into between in connection with the REPS case, charges under section, my lord, 498A.
NDPS,
No, my lord.
what,
Nari police station case number. Charges under 498A.
Nari PS,
Yes, my lord. Charges under 498A. which is-
498.
Yes, my lord, it is not compoundable. Otherwise, rest of 323 simple injury, then 506 both are compoundable. So I am before your lordship. Case is charge sheeted, but yet not taken cognizance. So it's still,
but registered there.
yes, my lord. The charge sheet has been filed before learned CGM Pasigat during the year 2021, but it's still not yet taken cognizance, my lord.
The case is of which year? 2021,
Yes, my lord.
yes. So,
My lord, this matter can be quashed in the motion stage itself because it's a husband-wife
it
dispute.
appears.
So without
is-
calling for the record, because your lordship, the sections which has been incorporated is 498A.
Hmm.
It clearly shows that it is a dispute of husband-wife, and 323 is a compoundable offense,
Mhm.
and 506 as well, my lord. So in the motion stage itself, your lordship, this matter can be disposed of.
Okay. Where is the agreement?
Agreement, my lord, at page number 48, annexure 3, my lord.
Okay,
48 and 49.
I'll take the relevant information, huh? Okay. Mr.
P. Tamil.
Learning Counsel for the petitioner. Also heard Mr. Theatre, an additional PP for the state. This is a joint application filed under section 528 of BNSS 2023 by the accused petitioner number 1 within bracket, huh? And no. It's informed by the informant petitioner number 1 and the accused petitioner number 2 in Nari PS case number 14 2021, praying for setting aside and quashing of the charge sheet file. No, GR case, where is the GR case?
My lord,
Is the case is pending before the CJM?
yes, my lord.
What is the GR case number?
105 of
Okay,
21.
Okay, setting aside and quashing of GR case number, GR number 105 2021, arising out of Nari police station case number 08 2021 under section 498A, capital A, stroke 323, stroke 506 IPC. Stop. the brief prosecution case is that based on the written FIR lodged by the petitioner number 1, wife, within bracket wife, on 14 May against her husband, petitioner number 2. Inter alia alleging therein that she has been subject to a cruelty at the hands of her husband, petitioner number 2. The above Nari PS case has been registered under section 9E. Registered stuff. Upon completion of investigation, the investigating officer submitted charge sheet into the case against accused petitioner number 2 for offense under section 498 capital A 323 506 IPC. And now the case is pending trial before the Chief Judicial Magistrate. Pasigat.
Yes, my lord. Passing.
Okay. The Land Council for the petitioner submits that during the pendency of the trial, the parties have resolved their dispute, amicably resolved their dispute. And executed a mutual settlement deed on 16/9/2025. Wherein it is precisely stated that the matter has the matter has amicably been resolved between the parties with the intervention of the elders and relatives. As both the wife and husband are after the incident has been living together. Now, as the informant and the accused has been living together after the incident, has been living together as wife and husband, and upbringing their 3 children without any animosity and differences stuff. The settlement deed also contained that since the matter has amicably been settled, the informant wife has no further grievances against the accused husband, and she does not want to pursue the matter any further. in light of the above for the petitioner, prays for petition submits that since the parties have amicably settled the resolved the dispute and dispute. As such, there is no chance of any conviction in the case. Therefore, pray for setting aside and quashing of the proceeding in the case. Stop. Para. The learned, the Mr. the learned public additional PP clearly submits that in view of the amicable settlement between the parties and is the between the parties being wife and husband, and as the parties are staying together immediately after the incident, he has no objection if the prayer of the petitioner is allowed. Okay, rest I'll conclude.
Yes, sir. Obliged, Your Lordship. Item number 2.
My lord, before my friend start in this case, Your Lordship, we have an objection for impleading us as a party, Your Lord. Because it's a domestic, Your Lordship, they are challenging the maintenance case.
Okay,
And state has no role in their is not prosecuting anyone, my lord, in this case. But we have been aired as a party in domestic
there is a provision,
Men-
I think, in the
yes.
domestic.
maintenance, my lord. Maintenance
Maintenance.
case under
Isn't
125.
there any provision under the maintenance CRPC?
No.
What do you mean?
Here I'm challenging the order passed by the learned trial court.
What order was passed by Lanik?
The maintenance order passed by the learned trial court.
Okay,
So therefore,
there is no appeal provision under the CRPC before the.
in the order itself, the interlocutory order. That's why I am prepared this quashing petition, because there is no such a case made out against the alleged dispute. 125 CRPC clause 4 is violation by the learned trial court. Therefore, I prepared this quashing petition. The 125 clause 4 provides where the Wait.
Can you see the provision? BNSS. What next? Read. What is the corresponding BNSS? One it.
144.
144. ma'am.
One 46.
144 is the, Your Lordship, order for maintenance of wife, children.
Yes. Alteration. If you are aggrieved,
Yes, alteration application was also made, but it was not accepted. Alteration application was also made, it was not accepted.
you have challenged that order.
Yes, because as per provision, my lord, here, maintenance order is a interlocutory, there's interim order. So since the provision is violated by the learned trial,
Has been violated.
125 CRPC clause 4. In that
What is clause 4?
clause 4, my lord, here, wife disentitled to receive any maintenance from the husband. May I read the provision? Clause 4. No wife shall be entitled to receive an allowance for the
Clause 4,
maintenance.
144, clause 4.
140, I'm reading CRPC 125 because this order was passed under CRPC.
Corresponding to 144 subsection 4, madam.
Okay.
No wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and so as the case may be
from her husband under this section if she is living in adultery, or if without any sufficient reason she refused to live with her husband, or if any living
For that,
separately by
have you
mutual
proved?
consent.
For that, have you proved?
Yes, I have one file affidavit. It was same place before the.
This is, for that, you have to prove that she is living in adultery.
Yes,
She
sir.
has a sufficient means.
Without any sufficient means, she voluntarily living separately. And
You have
without
to
any-
prove that. You have to prove
sir.
that.
My lord,
How this High Court can prove that?
my lord, I have a affidavit, a declaration submitted by the mediator who repeatedly attempted to reconcile and negotiate the discord between the husband and wife. While discussing, family discussing that
You have to
respondent
prove
wife
before the court.
affidavit in the form of affidavit. This is
You have
a
to-
document.
No. You have to prove before the court that she has sufficient means and she is living adultery and she has deserted,
My lord,
You
page
have to
number
prove that
78,
before the
I
court
have one
only.
document.
not by sending arbitrator. Unless you prove that.
One affidavit I have filed.
What
four person-
affidavit before? Which
affidavit
court?
notary,
Notary.
yeah, declaration.
That declaration can be anything. You may declare yourself as a lady also. They will sign it. Affidavit can be declared anything. You have to prove it before the court only.
Moreover, in this case connection, the respondent will file one FIR also, and here FIR 161 statement before the police also. The entire witness disclosed that the respondent will voluntarily leave the society of the husband.
That is why I'm saying you have to prove what your allegation before the court only, and in the final order, the court will dismiss the claim petition itself. You have to prove before the court, not by declaring your self-declaration is nothing. Self-declaration, you cannot just show it before the court, High Court. You show it before the trial court, prove it.
And moreover, the pending maintenance petition of the trial court. Here, petition itself, there is no cause of action arose.
You raise
Because
the-
cause of action
this question
arose
before the
that
court.
the respondent wife respondent wife could not
See,
live with the
If there are
husband.
so many things, you have to do it before the court only, trial court only. This court cannot. And in the maintenance petition, why you have included the government? What the government is to do with,
Yes, this only since we are challenging the order passed by Lanet Court below only. That's why I think
no, go through the provision first. You have to adjust the provisions, the provisions provided under the CRPC or BNSS. Thereafter only you have to come.
so. Well, that case,
Before the
my
trial
lord,
court, you have to
let
adjust.
this matter may be listed again another after vacation. So I will come with the authority whether that the 125 clause 4 has to be proved before the trial court without proving the such any document available to show. Then we may approach before the Honorable High Court for quashing of the pending maintenance petition.
Even in the divorce case also, maintenance you have to provide. Whatever may be. When do you want to do it? I think you have to come prepared. I haven't seen it properly.
Your Lordship, let them first strike out the state, my lord.
Hmm.
It's between husband and wife.
It is only between husband and wife. Order was passed in her favor. Case was between wife and husband. Okay. Mr. Tarum, P. Tarum, Land Council for the petitioner. Submit that the state arrayed as respondent number 1 is not a necessary party in this proceeding. We have a pray for striking of the name of the state, respondent number 1, state of AP. So the public prosecutor. Stop. The prayer is allowed. The respondent number 1 stands. Okay, the name of the respondent number 1. Let the name of the respondent number 1 be struck off from the court title. Stop. The Rani Council further prays for listing this matter. When?
After vacation,
After vacation.
after puja petition.
I think you better come to here. And then there is an option. You can file before the trial court. Huh? Explore that first. Okay, then come to here. Praise for listing this matter. Pray for listing this matter after 2 weeks. Prayer allowed. List this matter after 2 weeks.
Obliged, Your Lordship.
Highly obliged.
Item number 3.
May I please, Your Lordship? Your Lordship, this is a joint application filed under section 528 of BNS for the quashing and set aside the proceeding of the Procedural PS 52/2009, which was pending before the district and session judge UP. On the ground of set,
This 376.
yes, Your Lordship.
At the stage of the
Uh,
376. Why when husband?
no,
Okay. But it's a joint petition.
yes, Your Lordship.
Oh,
Actually,
that's
Your
the
Lordship, incident was happened on 5 September 2009. Then on the 8th of September also, once the kebang has been held and the complainant she has decided to forgive the Alice accused person, Your Lordship. I have enclosed the death documents also.
Can it be forgiven?
Moreover, Your Honor,
Comparable case after
yes,
registered.
this is, yes. And
How can it be?
Your Lordship, then,
He cannot. Even if she cry also.
yes, Your Honor, but Your Honor,
She can-
they have amicably
Already
settled the
registered.
issues. They have amicably settled. But Your Honor,
376 cannot be amicably settled.
but Your Honor, in the deposition also, she has mentioned, in her deposition, she has mentioned that she has already forgive the, and matter has been already settled in the kebang.
Kebang cannot settle
But-
376. Where is the settlement?
Your Honor,
Who suggested to settle 376 in Kebang?
Your Honor, date of settlement is on 3/2/45.
This cannot.
Uh,
Yes.
Yes, Your Lordship. Also, Your Lordship will see that the trial must have been in the stage, last stage, because
What is the status of the trial?
PWS. Prosecution witness statement,
Completed.
evidence.
Complete.
Yes, Your Honor.
Okay. And then what about the defense?
I have enclosed all the depositions in my
Okay.
page number 46 to 49.
What is this? Page 51. Full payment.
Your Honor, this page 51 is the kebang which was held in between the parties,
Okay.
between the complainant and the alleged accused person.
Okay. Accused paid some fine.
Yes.
Oh. Complete.
Your Honor, they did not want to pursue the
becomes
matter.
It's admission.
yes, admitting.
This has been whether this document was placed before the trial court. It's a complete admission.
No, also, Your Lordship, I had always,
This is a proof that he has committed. He
I
has admitted his guilt.
had always had an issue with this, Your Lordship. once the investigation starts and an FIR is being filed, Your Lordship, will any of the village authority have any jurisdiction to try upon those cases which are still under investigation? That is also one part, because if these documents are to
Cannot.
be relied upon, Your Lordship.
Cannot.
And also, Your Lordship will see why my submission before Your Lordship is that the IO was last examined in the year 2018. Your Lordship will see at page number 49.
The case of which year?
This is a case of 2009, Your Lordship.
Okay. The
49.
case will not die because of elapse of time.
Yes. Page number 49, Your Lordship will see the IO was the deposition of the IO was taken on year 2018, Your Lordship.
Now I think
Now it-
final stage when
yes.
probably he knew that he will be convicted. That is why agreement entered. So this is IO, page 49.
49. Your Lordship will see the date of
Implicated.
deposition is 21st day of May 2018, Your Lordship.
Yes. Yes, 2018.
Yes. If that is the case, Your Lordship, the trial must have be in the stage of
Have you
final stage.
have you annexed the last order passed by the trial court? When the last order and what was for it?
No, Your.
Hmm?
No.
See, this is difficult. It will really be difficult. So what do we do?
Your Lordship may otherwise call for the record. At least we can see at what stage. Otherwise, also, Your Lordship has rightly pointed out 376. Even if there is any agreement whatsoever, Your Lordship, it cannot be quashed since it's not even a private offense. Your Lordship.
It cannot be. And then see the agreement, payment of fine. This is an indication of that pleading guilty. And this, while before annexing such document before the court, the Law Council should also take care of any agreement by the and payment is admission of guilt if it is exhibited before the court.
Yes.
It is, although this is Arunachal, but then we cannot allow, although we are allowing so many quashing petitions in case of wife and husband and in the minor or petty cases or small theft or trespass, but then this kind of case, if we start, will be difficult. Then see, there will be no law at all, no court at all. Court will not be necessary. Okay, then third, Miss
See, Irin.
Siri, Land Council for the petitioner. This is an application filed under section 528 of BNSS 2023, seeking quashing and setting aside the proceeding of the Procedural. Where is the, okay, it's not a GR case, it should be session case. Why you have mentioned GR case? This is tribal by the session court only.
Yes.
Why you have mentioned? GR case is before the magistrate court, must be before the committal proceeding. Where is the session case number you have mentioned? Have you mentioned
No,
anywhere?
Your Lordship. Only the double PS number on PS case number on that.
See, the trial almost completed, maybe complete, but then you have you failed to mention the case number also. You have not done anything. It's not a no longer the PS case or the GR case. It's a session case only. Where is that? How do we call? Which record do we call for? Because the case is pending before the trial session court. Which court it is pending?
And District and Session Court UP.
UPIA?
Yes.
Then where is that? This is not the,
No,
not
the-
the Porijo case.
Yes, although it is Daporijo case, but they have transferred the matter here. District and Session Court UP.
Okay,
Petitioner number was.
now
is
you
recent-
know, it appears that it's
Yes,
not
sir.
a Daporijo, but you have mentioned Daporijo GR case. It's- But the record is at UPIA. So we'll direct the district session court UPIA to find out this gentleman's case and then send.
Your amendment, amendment for the petition may be allowed.
Now you see, then your prayer, entire thing will change. Because in the body of the petition also, you have mentioned only GR case, Daporijo, PS case, Daporijo PS case only, and GR case, which is in Daporijo. And then there is no prayer for the quashing and setting aside of that session case. I think you need to amend entire thing.
Liberty may,
See, prayer also, Daporijo PS case only.
Yellow, sir, liberty may be given.
I think you make a small, at least before filing, whether it is small or big case, you have to make a research,
Yes, sir.
undertake a little bit of research, then only file. Think of pros and cons of the case. Okay, Miss, okay, who wants to withdraw this petition with liberty to file FS after making necessary correction. The prayer is this criminal petition is dismissed on being withdrawn with liberty as prayed for. Okay.
Much of it.
Matter number 4. May I please, Lordship?
Yes.
Lordship, the petitioner before your Lordship is praying for a quashing of the FIR, setting aside and quashing of FIR in respect of the petitioner only, Lordship.
Okay.
Lordship,
So there are more accused.
yes, prime accused has been arrested and he is still in the police custody. Daporijo PS. Lordship,
Daporijo.
yes. My Lordship has already granted the interim and made it absolute in respect of the present applicant. Interim bail was granted, Lordship. Lordship,
They are in this case.
yes, in the same petitioner, Lordship. Lordship, the brief fact of the case is, Lordship, on dated 1/5/2022, there was a lease agreement, Lordship, for running of petrol farm retail outlet, Lordship, MS Sibansiri Energy Station, Daporijo. The agreement was entered between the wife of the complainant and the prime accused person who is presently under the police custody, Daporijo. The agreement was entered for running of the said petrol farm by the accused person. And in the said agreement, Lordship, entire clause has been inserted whereby the accused person who will run that petrol farm will liable to pay and clear all government tax, dues, etc. Whatever may be, Lordship. And in the said agreement, the present petitioner, being an uncle of the person, he was one of the witnesses to that agreement only, Lordship.
He is only witness.
Yes, witness to that agreement only.
Okay, anyway, so, but he is protected.
Yes, the interim and absolute was also granted, Lordship.
Okay,
Lordship.
so, that means, according to you, you are not involved in the case.
No, nowhere, Lordship. The allegation in the entire FIR
It
is
is
for
against the main accused.
non-payment and evasion of the bad tax.
Nowhere your name is mentioned in the FIR.
Yeah, my name is mentioned, Lordship. I
Mentioned
have been
as what?
mentioned as one of the main, Lordship.
Okay, then, your
Lordship.
name.
Yes, as for FIR.
Huh.
But Lordship, in the meantime, the complainant has served a self-calculated the bad dues, and that was also immediately cleared by the accused person who has been arrested in the police custody. So, Lordship, I am nowhere connected and nowhere involved. And after clearance of that bed and fresh agreement was entered between them only, whereby they have already settled
dispute and
Thereafter, you are no longer involved.
no longer in
But
press agreement also I was not
The complaint is against the first.
against the first and me also because I was the witness.
Okay.
May I take you to the FIR, Lordship?
But according to you, thereafter, there has been agreement.
Yeah.
And there has been agreement.
Yes.
And in the agreement, what they has, what is the solution with regards to the FIR already lodged earlier?
Yes,
In
but
the agreement,
in the agreement, Lordship, they have decided to withdraw. That is
but then the case proceeded.
case procedure. Case is still pending, but that accused person is still under police custody, Lordship.
Police custody.
Yes. Now,
How many accused? You and
me and the prime accused.
men?
Yeah.
But in any, Ms. Chini,
Your Lordship may call for the
Call for-
CD, Your Lordship, since
Mm.
it's still under
it's CD only,
investigation.
still under investigation.
Yes.
Okay. Third, Mr. Kelole, Learning Council for the petitioner. This is an application filed under section 528 of the BNSS 2023, praying for quashing of FIR dated 29/8/2025 in respect of the petitioner registered under FIR dated so and so, registered
Is the
Is-
original.
the Porijo PS case number 60/2025 under section 316 within bracket 5/318 within bracket 4 BNS 2023 in respect of the petition, present petitioner. Stop. Call for the scanned copy of the case diary. Issue office. Since Ms. Jeannie, learn additional PP. Appear and accept the notice on behalf of the statement number 1. No formal notice required to be issued to the said respondent. Stop the petition. However, the petitioner shall take steps upon the respondent number 2 by a registered post which as well as by usual process within a week from today. Within 3 days. So I
Sunday,
think it's okay. How many days?
within a week.
Within a week from
Yes.
today. Stop. List is met. Then it will be
On 23rd of October, Your Lordship.
23rd. Okay. List is matter on 23rd October. Okay.
Deeply obliged.
Item number 5.
Yes, my lord.
Yeah.
This is a joint petition, my lord,
Very good.
by the informants as well as the alleged accused persons.
Okay. Who is the informant? What is the allegation?
The allegation is, Your Honor, trespassing and damaging of the house staffs, Your Honor. And Your Honor, it is to inform before the informant is the second wife of the accused person's husband. And the facts of the case is, Your Honor, on the day of incident, only the facts came to know that accused person's husband is living with the informant as a husband and wife. So on that occasion, slight pushing and pulling happened between the parties, and where on the grievances of that she may not be accepted as her a second wife. So FIR was big loss. And accordingly, after the family settlement, and informant has submit on one application before the OC for closure of the FIR. And we have annexed the application, Your Honor.
When this FIR was lodged?
Your Honor, FIR was lodged on 14th of June, 2025.
What is the
Allegation,
status of the investigation?
charge sheet is yet to file, Your Honor.
Not yet filed.
Yes, Your. And Your Honor, and the more facts is that prime accused, the wife of the husband, the first wife, she was
Hmm.
detained for 14 days. Only on the ground of lactating mother, she was released. And we have also, Your Honor,
Accused is the first wife.
accused is the first wife, yes. There are two all
How many
allegation
accused are there?
against the, altogether there is allegation against
More
two
than
more
20%.
accused.
More than 20%.
And
More than 20%.
yes, allegation is
This
like that.
application is in respect of only one.
The accused, there is, as per the official record, there is only 3 accused being yet recorded. Allegation is against the
But
around
the
20 members.
investigation is still, the investigation is still on.
Yes, Your Honor.
It's
Okay.
premature
Who are
to
be arrested?
interfere with the investigations.
Your Honor,
It's premature stage to interfere with the investigations, and the investigation has to go on.
Now, that is why I'm saying.
yes, Your Honor,
So the allegation is against around 20%.
20%, yes.
Now till now, only 3%
3%, yes.
Arrested.
It is, Your Honor,
arrests are
actually,
yet to be arrested.
actually the allegation of 20% and allegation away of 12 lakhs is a mere allegation. Is settlement has been done, Your Honor. If we allowed to go through the
No.
settlement, Your Honor, settlement is being done by the informant.
Okay. You are granted bail.
Yes, granted bail. And
How many
two more alleged accused person has been released on anticipatory bail.
2 on anticipatory bail,
Yes,
one
sir.
on
That means
one on regular bail.
Yes, Your Honor.
Okay. So now the case is still under investigation. 2 more
Yes.
are yet to be
if
arrested. Interfere with-
2 persons
Yes,
were
sorry.
already gotten bail from the lower court, they are in liberty. So investigation has to go on.
Whether, how many applicants are there?
Applicants, 3 applicants, Your Honor.
3.
As
All-
because as of now, there is no findings of involvement of 20%, Your Honor. And Your Honor, as per my understanding, the very nature of the case is a private in nature in between the family members, you know. The second wife and first
we have
wife and
no
the
idea,
husband.
But the allegation is attempt to murder.
Yes, allegation is tapped and
Now we do not know what is the fact. Need to go for the record. The allegation is serious.
Exactly, your loss.
Hard,
Well-
Mr.
Tidon. Tayadon.
T?
Tayadon, yeah.
Don,
Yes, Your Honor.
learning counsel for the petitioner. This is an application filed under section 528 of the BNSS 2023, read with Article 227 of the Constitution of India, praying for quashing of the FIR dated 14/6/2025, registered as Chimbu PS case number 37/25 under section 329 within bracket 4, 333, 304, 304, I've seen 351 within bracket 3, 115 within bracket 2, 324 within bracket 5, 3 within bracket 5 of BNS 2023. Just a minute, where I have seen 307. See, the register is 307. You have written here somewhere 304. What?
Yeah,
how
you know, it's a
304?
clerical mistake. It should be 307.
Yes,
307, yeah.
correct it. Huh?
Yes.
Instead of 304, it should be 307. Call for,
it was registered under the BNS 307, something about language of the court.
It's a theft, Your Honor.
oh, this is BNS.
Yes, Your Honor.
IP was
Yes, BNS, huh?
Yes, Your Honor.
What is this 329?
Sorry, my lord.
What is this 329 for?
329 is for
And 333,
333 house trespass.
304,
It
not
is a
304, 307,
307 is theft after preparation for causing death, hurt, or restraint in order to committing of theft.
yes, yes.
Yes.
351,
351 criminal intimidation, you know. It is compoundable.
okay. What about 115,
Yes, you know.
115?
And 115 is voluntary causing hurt. It is also compoundable.
Okay,
And 324 is mischief, you know.
okay. Then it's
And 3/5 is common intention.
call for the scan copy of the case diary, issue notice. Since Mr. Additional PP accepts the notice on behalf of the state, no formal notice need be issued. So, list this matter
After vacation.
after vacation. Okay. Immediately after vacation.
Yes.
yes, we are calling for CD.
Yes. Scan copy. huh?
Oblige.
Much obliged.
Item number 6.
Naples, my lord.
My lord, this criminal petition is quashing of FIR dated
Yes.
FIR dated 14/10/24
What is the allegation?
connection with-
against whom?
in connection with Papu Hill Police Station case number 73/24. So this petition is filed jointly by the petitioners. 5 petitioners. So, my lord, the allegation is, my lord, it's due to the misunderstanding, my lord. There's a scuffle occurred between the petitioners, leading to the lodging of aforesaid FIR. So, my lord, allegation is
What is 74?
74, section 74 is for assault or use of criminal force to the woman with intention to outrage her modesty. This section,
118, 101?
my lord, 18.1 actually, initially it was registered on 18.1, but after investigation, 115.2 was inserted.
Okay,
In-
what is the 18 and what, 118 and what?
15, my lord,
15?
15 is voluntary causing hurt. This is compoundable.
Okay.
And then regarding
126?
26.1, it's for a wrongful restraint. It's also compoundable. And
So 74 is non-comparable.
yes, only 74 is compoundable. Now, my lord, the fact of the case is, my lord, what is the fact of the case, my lord? Actually, my lord, the case is on 14/10/24. Petitioner number 1 met her husband at the railway station with petitioner number 5, who is a complainant in this case, at around 11 p.m. So petitioner number 1 asked petitioner number 5 why she was with her husband late at night. But before petitioner number 5 could respond, the husband of the petitioner intervened, which led to the incident in question. So this is because of this ground.
Okay,
It was
so
Now,
This is the case between girlfriend of a husband, lordship, assaulted by the wife, lordship. So I have no objection if
since settlement has been already between the parties, already they have already settled the court, my lord. Now, since it has been already settled, so my prayer is to quash the FIR.
The case is before which court?
Before actually, my lord, this is not yet take cognizance, my lord. Though it is filed charge sheeted, but not yet take cognizance, my lord.
Which court?
Uh,
No,
Learned
must
JMFC.
have been registered then.
Learned JMFC. Trial is not yet started.
We'll call for the scan copy.
yes.
Hard, Mr. Is okay. Let us see the record.
Yes, sir.
Okay.
Yes.
When charge sheet was filed,
My lord, may kindly.
when the incident took place, then?
Incident took place in 10/24 itself, my lord.
Oh, 24.
Yes. Then charge sheet was filed on 7/4/2025, my lord.
Okay.
My lord, it's only
See
just
that.
a simple scuffle between the parties, my lord.
Okay. This is an application file under section 538 of the Act. Paying for quashing of the criminal proceeding in GR case number. Where have you mentioned?
GR case number, my lord, GR case number 1058/24.
GR case. Where have you mentioned?
Para 6, my lord.
Para 6.
Hmm.
GR case number 1058/2024 arising out of Papur Hill Police Station case number 73/2024 under section 74/105 within bracket 2, 126 within bracket 1, 3 within bracket 5 B and S pending before. The which court you said?
Learned JMFC, UP.
The Court of Judicial Magistrate, first class UPI. Call for the scanned copy of the trial court record to notice since Mr. Loy Lanipiti appear and accept notice on behalf of the state respondent. The formal notice is waived. Staff, list this matter. Next week?
Next week.
Okay. List this matter on 25. Today is?
Today is 19 November.
Okay, 25.
Yep.
Item number 7.
Yes, Mr. Kato, is there any case here?
No, my lord. My lord, ultimately it has to be decided by the trial court, my lord.
It has to be, so it has to go.
Yes,
The sentence should be expunged. Which one?
No, my lord, this is item number 7, civil revision petition, my lord. Civil revision.
You are for?
I am for the respondent, my lord. I am,
Yes.
I filed, my lord, the.
What is the
title.
prayer? The prayer is to be taken up next week.
Then, my lord, in that case, my lord, on Tuesday, man.
Tuesday.
Otherwise, my lord, there is
Just
no
a-
merit
just
in the
a minute.
case,
I have
is
found
because
something.
ultimately.
The prayer was only limited,
Yes, my lord.
limited prayer. That there was a, while disposing of the,
Miscellaneous application.
what is this? Of this, the court of so and so, miscase.
My lord.
Miscase is for what?
But they, my lord,
Under section 11 of the CPC,
yes, my lord.
and then the learned court has made an observation saying that the possession of the lane is under possession of the plaintiff. But then this such observation probably would adversely affect.
No, my lord, there, he raised the objections that my lord, it is the suit, the pending before the learned trial court is barred by, my lord, the of res judicata, my lord. Whereas I was not the party, I am the owner of the lane, my lord. I was not the party in the village level proceedings, my lord. And that village level proceedings was also part
No.
of it, my lord.
So that is why this application was dismissed, rejected.
Yes, my lord. It was filed by them only, my lord.
Yes, it was rejected. Okay,
Yes, my lord.
but then he has a grievance before this court that while rejecting his application,
Madam.
the learned court has made some observation wherein the learned court has declared that the lane was under possession of the applicant plaintiff. So this he wanted by filing this application, he wanted that
Yes, my lord,
sentence
that
to be expunged.
with that observations, my lord, the matter may be remanded.
Yes,
If that is the subject matter of the, my lord,
Yes. That is the subject matter, and
title
it cannot be decided in this case. That is what I am saying.
True, my lord. My lord, in that case, matter may be remanded. In the meantime, my lord, that particular may be expunged. This is subject matter of
Yes.
the title suit.
Yes,
That
yes.
is to be decided
Because this is the
ultimately
main
by the
issue.
trial court, my lord.
This is the main issue, and
Yes,
main
ma'am.
issue cannot be decided in the miss case.
Exactly, my lord.
So this amount to decision of the decision of the case itself,
My lord.
and it will adversely affect.
No, my lord, my understanding is, my lord, this
That's
will be
fine.
not directly affect as a decree or the order. This is,
We'll
this is the
make an observation.
tentative maybe, my lord, the
Make an observation. This will not. This
tentative
will not be
observation
taken.
of the, my lord, since
Right.
our fleet,
Ah.
my lord, degree has to be determined by leading, my lord, entire.
Right,
procedure, my lord. So therefore, my lord, this is the tentative view of the learned court below, trial court,
Mhm.
that this is the claim of the, my lord, the petitioner, my lord, the plaintiff therein, my lord, respondent here in this civil revision petition, that land belongs to me, my lord. So that could be the tentative view, my lord. But that has not been final decision, and that is not final yet, my lord, the decree, and that will be not
We'll
governed.
say that this will not be taken as a final decision.
Yes,
Just
madam.
say-
This is something like in, madam,
Such observation, of course, normally in this case is not made. But then
Madam.
since it has been made, we'll say that this will not be taken.
this is
Because
just mere
this
observation,
can be
madam.
decided only after reading the evidence.
Just, madam, this is just mere observation, madam.
And
My lord,
the
if-
suit lane is in possession.
If, my lord, again,
And
my
then
lord,
see, thus it can be prima facie hold that the possession of the suit lane is with plaintiff.
then, my lord, another proposition is, my lord, it is barred by limitation, my lord. Sorry, my lord, res judicata, my
Res
lord.
judicata.
Again, my lord, I'll be nowhere, man.
No. Res judicata, that will uphold.
So therefore,
Well,
my lord, it is
that-
something
that
like,
res
my lord,
judicata part,
interlocutory order, man.
The case was rejected. This will uphold the res judicata part.
Yes, my lord.
Okay. And then only expunge this sentence only. While upholding the decision of the trial court, decision of the civil judge, rejecting the rejecting the prayer on, okay,
Madam.
that will be upheld
Madam.
by this court. Only this sentence will be expunged.
My lord, without expunging also, my lord, the observation made will not be, my lord, the ground for the
And-
leading in the evidence.
Yes, yes,
My lord,
that
by that
sentence automatically will come.
my lord,
Automatically.
without also expunging the, my lord, word, this is the tentative view that which will be not, my lord,
Not
having-
taken.
taken into consideration for the disposal of the, my lord. It has to be decided in accordance with law, my lord.
Okay.
Subject matter is, of course, pending before the court, my lord. It has to be decided on its own merit of the case, my lord.
I'll take that. Just fact, huh? Mr.
That's it.
Hmm?
That's it.
Yes, Shiran. Learned counsel for the petitioner. I've also heard Mr. M. Kato, learned counsel appearing on sole respondent.
Two respondents, my lord.
Okay, for respondents. Both the respondents
Both the respondents.
appearing on behalf of both the respondents. 1 and 2. Start. Who filed the plaint? You are the petitioner.
Yes, ma'am. I'm the plaintiff in the title suit.
The fact of the case is that the respondent hearing has filed number 16,
Correct, ma'am.
2022,
22.
before the Court of Civil Judge, Senior Division. Hello. That was for declaration. Declaration of
Title,
where
rights, my lord. It is in page number
declaration of
53 of the
page.
page number 53 of the civil revision petition, my lord.
Okay,
Annexure
just
10, ma'am. Page 53, ma'am.
5.2. So declaration right title
For a land measuring, my lord,
Okay.
for
for
540.6.
53. Where?
Page 53, my lord.
53.
Cost title, ma'am.
Plain. Where is the prayer?
There portion is at page number, my lord,
Declaration of the
page
Title.
62, my lord.
ownership right and land measuring 540.6 square meters located at Liperizo area, Basar. Declaration of right title interest over the suit land, in favor of the plaintiff. Measuring 5.6 square meter located at Liperizo area, Basar. Stop. The respondent petitioner hearing file miscellaneous application number 42/2022 in title suit number 16/2022 under section 11 of the CPC for dismissal of the suit on principle of res judicata. Stop. The said application, said miscellaneous application number 42/2022 was disposed of by the Lanet Senior Judge Civil Division Alo on 17/3/2023. And rejected. And the prayer, just a minute. And the prayer was just the rejected. Stop. However, while rejecting the application under section 11 of the CPC for dismissal of the suit on principle of rest, the Lanet civil judge has made an observation, made some observation that the suit lane is in possession of the plaintiff number 1, which is recognized by the competent authority by issuing LPC on 10/4/2006, and thus it can be prima facie hold that the possession of the suit lane is with plaintiff number 1 since 2006. Stop. Para being agreed by the said observation of the civil judge senior division. The petitioner filed this application under section 115 of civil procedure code, read with section 27 of the Indian the Constitution, Indian Constitution. And praise for expunge of the sentence. Expunge of the striking out of part of the order that is within inverted comma, and the suit lane within inverted comma, you're right. And the suit lane is in possession of plaintiff number 1, which is recognized by the competent authority by issuing LPC wide number WS/REV 16/39 within bracket EP capital bracket close of dated 10th April 2006 within bracket document number 2 bracket close stop. Thus, it can be prima facie hold that the possession of the suit lane is with plaintiff number 1 since 2006 inverted comma close. Stop. The limited prayer of petitioner in this civil revision petition expunge the above observation made by the Lanet Civil Judge Senior Division on the ground that this amounts to this amounts to the above observation is subject matter of the suit, and by making observation amounts to deciding of the suit itself, and thus it adversely affect and prejudice the case of the petitioner. It will prejudice the case of the petitioner for trial proceeding in the title suit. Start. Mr. Kato, Learned Counsel for appearing on behalf of the both the respondent number 1 and 2, fairly submits that consider the submission of the Learned Counsel for the petitioner. However, he submits that submits that the rejection of the miscellaneous application for rejection of the miscellaneous application made under section 11 of the CPC for dismissal of the suit on principle of res judicata may be retained. Yeah? So that will, your prayer is that rejection should be retained.
Yes, good.
Although this may be expunged or dismissed.
This particular line may not have bearing
Yes,
effect on the
okay.
proceeding.
In view of the above. Okay. In view of the above, this civil revision petition is disposed of to the following order. Come, colon, huh? The observation. Repeat that, huh? That with inverted comma shall be expunged from the order and shall not affect for the further trial of the case. Okay. However,
Issue has to be decided
however,
in accordance with.
however, the order rejection of the application under application made under section 11 of the shall stand, remain stand. Okay. On the however, what did I say? However, the rejection of the application under section 11 of the CPC for dismissal of the suit on principle of res judicata shall remain stand.
Yes.
Okay. I'll make necessary correction here in the okay. With this civil revision petition stands disposal. Okay.
Right.
Is there any stay order? No. No stay order.
Well, there is no stay.
No.
Leave level.
Item number 10.
Yes.
May I please allow?
Item 10.
This, my lord, application file under section 15. clause
15?
Section 23, clause 3 of the Ordinance for the Civil Code Act, my lord. As the lordship knows, CPC 151. Section 15 is the Lord appeal from the decree.
This is second appeal.
Yes, my lord. Revision, regular second appeal. Clause 1, appeal from the decree or the order passed by the court of district judge and the Court of Additional District Judge in Port
Where are you reading?
and 14 of the
You are reading which portion?
section 50.
15.
Clause 1. Page of the area.
Section 15,
Yes,
appeal.
Yes.
Yes, okay. 1 or 2?
1.
Okay.
Appeal from the decree or the order passed by the Court of District Judge and the Court of an additional district judge in ordinal suit and postings of the civil matter said. When such appeal are allowed by the law, lies.
Okay.
Thereafter,
this is-
this come to section 23.
Okay.
Is section 23.
Yes.
Power to invest civil judge, senior civil division with jurisdiction under certain acts. Lordship, please come down to clause 3.
Yes.
Every order of the Court of District Judge passed on appeal under subsection of section 15 law. From the order of the civil judge, senior division shall be subject to an appeal to the High Court under the rules contained in the court applicable to the appeal from appellate. My lord, this is an appellate review.
This is the second appeal.
Second
So appeal was disposed of by
by
okay, against which order?
again order passed by the civil judge. Yeah.
What was the order? Order in what?
Order in the law,
Civil judge passed order in what petition?
civil judge order,
Title suit was decreed.
that was, my lord, condemnation.
Condemnation petition.
Yeah.
What is this condemnation petition? It's a title suit or it's a miscellaneous application?
It was an
It's an
Civil
interlocutory application only, condemnation.
civil appeal. Yeah. Fact of
Condemnation petition is whether it's a,
condemnation petition.
it's interlocutory application only.
Condemnation petition is filed in the civil.
Yes, but it is interlocutory application.
That
we
was,
agree.
that was interlocutory application.
Okay.
However,
And
it was
whether
mentioned
appeal
that-
lies against the order passed in the interlocutory application?
Yes.
Where? How?
Fact is that there was a dispute of the Zoom land title.
Forget about that. Let us come whether this condemnation petition and the Limitation Act is a main appeal or main case title suit or a interlocutory application. Okay, agreed that this is interlocutory application. Whether any order pass in the interlocutory application,
In order.
whether appeal lies against
the
such order.
interlocutory application before the learned civil judge, there was delay of 44
Okay,
for present and appeal or the death of filing appeal,
okay.
44 days.
Hmm.
After gone through the interlocutory application, appeal,
Hmm.
the learned civil judge,
Hmm.
senior division has condoned the 44 days.
Okay,
I
that's fine.
order that the 3,
Yes,
1/3/2020.
okay.
Against that order, the respondent,
Hmm.
herein and in the main original appeal,
Hmm.
has filed an appeal against that order 1/3.
That was appeal.
Yes, that was appeal.
It should not have been appeal.
Again, it was filed appeal before the additional district session. That
Appeal doesn't lie against the interlocutory application. It was appeal.
it was an appeal. That is, my lord, in page. Manu appeal.
How appeal lies against the interlocutory
That
application?
appeal was filed before the additional district session judge. My lord, as per the orders and orders, civil code, section 15 clause 2 of the act. Order passed by the civil judge can be filed before the district judge.
No. This was not appeal. They have filed in appeal against the interlocutor application. This should not have been actually admitted.
This is the lot 130 to 140, 130 to 140.
This was a missed case, number 5224 in continuation of delay.
No, that was my application, my lord. Before the
No, your application was accepted and then delay was condoned. 44
Yes.
days of delay was condoned
Yes.
by the line of civil judge.
yes,
But then against that civil judge order, this application condoning the delay of 44 days by the civil judge,
yes,
they have filed appeal. It appears.
that is my lord,
Not civil revision, it's appeal.
appeal. This is 130.
That should not have been appeal.
That is 130 of my application.
130?
Yes, Annexure 12.
How the appeal can be filed? 130.
Yes,
Uh,
130. In the court of additional district judge, Court La Parada district, Basar. This is Basar civil appeal number 04/2025. This is an application under section 15 clause 2 of Arunachal Pradesh Civil Code 2021, read with section 151 of the CPC for setting aside and quashing the order passed by the Land Civil Judge Senior Division, Upper Subansiri District, Zaporizhzhia on 1/3/2025. 1/3/2025 is the order which condoned the 44 days of delay to present.
This was appeal under Civil Code Act.
Yes, civil court.
See, this was an interlocutory order only. Appeal
And
normally are filed under against the decree, isn't it? Deciding the title, deciding the dispute between the parties.
I not hear parties have contested in for not to condone the 44 days delay for
Where is the appeal? Appeal is check out. This was filed appeal under
my appeal before the Lanet civil judge is page 68 million. This is application filed under section 96 and order 41 of the Civil Procedure Code
Just a minute,
1908, read with section 15 clause 4 of Arunachal Pradesh Civil.
that is whose application you are reading?
That is filed by me before the original civil court at Zaporizhzhia. That is 69.
No, you file
From-
appeal.
Yes.
How you can file appeal before?
My lord, I
The
have
trial
filed
court?
an appeal before the civil judge against the order, Kebang decision passed by the judge.
Okay. That was the first appeal according to you. What
According,
happened to your appeal?
my appeal is against the Kebang decision
Before which court?
before the civil judge, senior judge.
Okay. Then what happened to that?
Then on the date of filing of my civil appeal, there was delay of 44 days to file appeal before the civil. Then I have filed interlocutory application on this.
Okay, that was first appeal.
Yes, that was passed.
So then the filing before the district judge is a second appeal.
Second appeal by the respondent.
Okay, then this third appeal. How it is possible?
No,
Is there any provision for
no,
third
no,
appeal?
my lord, this first appeal, first case was against the miscellaneous application or interlocutory application.
Okay.
Petition was rendered by civil against that order of
Okay,
civil judge.
understood.
First
Let
appeal
us-
was
let us
filed
come-
before
come.
the district session judge. And then
See,
this
see,
second
see.
appeal,
Appeal, they must have filed under 96 or what?
as per my lord,
CPC?
yes.
It should be against the appeal. Against the decree.
Hmm.
No appeal lies from the decree passed by the court with the consent of the open. Question of law.
51 for the CPC. Section 151.
Appeal are normally filed against the decree where the disputes, be title, are decided by the trial court. Appeal lies, not against the interlocutory application, interlocutory order. But this was taken as appeal.
And after filing of this appeal against the judgment and order passed by the Ladat Civil Judge Senior Daporisha against order that is 1/3/25, in which order I have my condemnation.
What, according to you, is a question of law involved here? Substantial questions of law.
My lord,
Second
Section-
appeal is only under substantial question of law, but first appeal also, they have probably this first appeal, but then this was against the interlocutory application. This should not have been admitted.
that is why I'm wrong. Section.
No appeal lies against the
Section-
interlocutory
Section
order.
100 of the CPC says, second appeal can be before the High Court for the appeal authority.
Yes,
on
on
the
substantial question
substantive
only.
question of law.
What is the substantial question involved here?
In my present case.
Hmm.
My lord, here substantial question is that the section, under section 5 of the Limitation Act, the appellant have presented an interlocutory application before me.
So there's a confusion because appeal doesn't lie against the interlocutory order.
Yes, the appeal has been filed by the present respondent. And this appeal has been taken, registered as 04 of 2025 by the Ladat Additional District and Session Judge, wherein the Ladat Civil Judge condoned the delay of 44 days for filing an appeal, has been allowed by that Ladat judge. But then by the appellate court, district session judge was that order.
You have contested the appeal, first
I have
appeal.
contested the appeal.
You have raised objection against the appeal that
Yes.
no appeal lies
No, that question was not right.
against interlocutory application. No appeal lies. That was the
That
basic.
was
actually.
not.
That should have been the basic objection raised by you.
Well, by not dealing with that.
There also, even under section 15 also, only it was never a decree.
Yes.
Decision or see the discretionary power exercised by the civil judge in the condemnation petition, which is an interlocutory application. It was never the decree.
Yes.
It did not touch upon the merit of the case.
That is why
Now, where have you the workout, the substantial question involved according to you here, the second appeal. What is the substantial question? Question of law.
Lordship, I have not specifically made it out, but
That-
then I have made it ground.
It has to be admitted on the substantial question of law only. Unless there is a substantial question of law, second appeal, how do we admit? It has to be admitted on substantial question of law to decide. Unless there is the substantial question of law involved. Where is the question of admitting the second appeal? See, we need to take out or make some research before filing. Section 100.
Section 100. My Lord, I have made some ground in my appeal.
Forget about ground, unless there is a substantial question of law.
This is, my Lord, on mandatory.
Can you read section 100, second appeal? Second appeal.
Second appeal, I have not make any pleading in my present appeal.
Then this is the second appeal.
Second appeal, I have applied in the article to the civil court.
This is the second appeal.
It is below
Yeah.
section 23 says that the court's just order from district civil judge can be appealed before the district court, and from district court to the high court. My Lord, on that provision
To the high court. The high court, this is the second appeal. And then see, you have come under section 100.
I have
See.
I have mentioned that also under section.
Yes, you see your
in my
application. It's under 100 only, CPC. See? Read section 151, read with section 100 of Civil Procedure Code, then it is a second appeal.
That is why this is RSA.
Then you tell me
And then,
what to
Lord,
do.
my Lord, as per this Honorable Order Civil Code 23, clause 3.
So what I'm saying is there also, it has to be the decree, never a decree. The order was passed only in the interlocutory application.
Yes.
No appeal lies
Yes.
against the order passed in the interlocutory application. That is clear. And unless you make out that the case or the substantial questions of law involves, then how do this court proceed with? Under what provision? When you file under section 100? This is not KEBA. KEBA is different. You can argue so many things. Logic, illogic. But in here,
My Lord, when the
it has
when
to be
the appeal-
specifically substantial question of
when
law.
when the My Lord appeal is filed before the court below, and the application is presented under section 5 of the
See,
Immediate-
even this application, even here also you say section 2 for applicable to appeals from appellate decrees. Decrees.
Yeah.
It was never a decree. It was never a decree. Was it decree? Condonation of 44 days. It was never a decree. Here also you see, read your section 23(3) and then 15 also. From the decree, everywhere decree. It was never a decree. It has to be against the decree, the appeal. Yes. It has to be decree only. It was never, it didn't touch the merit of the case. It was only with regards to the delay, condonation of delay, interlocutory application. No second appeal lies, no appeal lies.
That part, my lord, it was
So
not raised
this-
for the.
this-
For all.
This, if you are agreed by, I'll suggest one, if you are agreed by the order passed by the session district judge, then either you can come by way of revision, read with 227 or read with 226. This cannot be in second appeal. If you think that you are substantially affected by the decision of the session court and it didn't have the jurisdiction under appeal, then it has to come under say, revision. You have to rethink. It cannot be a second appeal. Come under for revision. Read with 227. You understood?
Yes.
Then what do? You want to withdraw or dismiss?
Withdraw.
With liberty.
With liberty to file.
Okay, Mr. Okay, Mr. M. Boje, Dana Council for the appeal, want to withdraw this application. This petition, huh? With liberty to file appropriate application. Stop. The prayer is allowed. This appeal is dismissed on withdrawal with liberty is prayed for. Okay.
All right.
Lordship, there is a IA, Lordship.
IA is in view of the past. Main, huh? The IA also stands dismissed.
Item number 11.
Yes.
As per the earlier order, the scanning copy of the trial court report was 4-4. Now, as per the office note, the session court has endorsed the matter to the JMFC. But till yet, the JMFC has not taken the cognizance of that case.
This is a bail application. Yes, Lordship. It is a charge-sheeted, Lordship.
Charge-sheeted, and only in arms act, and punishment is minimum 2 years, and it can be extended to only 5 years, up to 5 years. But only one thing of the charge-sheet.
Just a minute, huh? Just a minute. No. Have we received the record?
No,
Oh,
sir, this year was called for.
trial court record was called for. Because subsequently after filing, probably the case was charge-sheeted.
This year was called on Lordship,
Yeah.
11-9 Lordship.
Yeah. Okay. So you have not yet.
Yes, Lordship. Normally the TCR called by the registry only, Lordship.
Is it?
Yes.
No, it was to the registry also, the registry only, the scanned copy of the trial court record, the requisition. The registry is directed to take necessary steps. It was directed to the registry.
Yes, only. Yes, register only, Lordship.
Hmm.
Not by the office of the people, Lordship.
No, no, this is
And then,
no TCR.
Hmm?
No TCR. Session court has endorsed the case to JMFC. Until yet, JMFC has not taken the cognizance.
okay. It is lying
Yes, it is like.
before the court of the,
So questions of calling
Yes,
TCR does not arise.
No, no.
Because it is not trial, under trial.
but then the record is there.
Yeah, record is there, and search sheet we have brought it, and then they also have shown the search sheet. Since it has not been tried, and search sheet has been shown,
What is the punishment you said?
punishment is minimum 2 years, and it can be extended to 5 years.
In all the section?
Yes,
Yes, section 25 is there, but what about this other section? 13 UAPA?
no, that is not.
Hmm?
Initially, when the case was registered, it was registered under 111.2
Yes, 111.3,
and B, 111.3, 111.6,
6,
oblique 3, right, 5.
5.
Even UPA Act, section 30. Mane, unlawful activities, prevention
Yes.
act, there 30. But
Hmm.
it was the initial registration will be said that. But when the case was investigated thoroughly by the investigating officer, he has not found any involvement
Okay.
of those sections in itself. He has filed charges only under Arms Act.
Only under Arms Act.
Only under Arms Act.
Okay. Now, that is why the record was necessary?
Now, record is here. Charge is here.
Maybe, but then we have to see.
Yes. Look at it. See.
No, see, we need to call from the,
Then now, TCR. What does mean by TCR? Taking the conclusion that by the mistake, when it is put in motion for trial, that is a TCR. And what I have pleaded.
so it was endorsed to the judicial magistrate's first class because it was only triable by the magistrate.
Magistrate, JMFC.
So immediately after receipt, the judicial magistrate's first class must have registered a case, and then probably the process also started. Hmm.
Not yet.
Okay, the projection sanction also obtained, it appears. Trial will proceed. No,
So wait for some time, Lordship. Be it 24, Lordship,
we have to see that.
without going through the record,
Yes,
Lordship.
okay. Okay,
One more interesting thing
okay,
in the search sheet.
Hmm.
No date of arrest. And no date. The accused was forwarded.
let us see the record.
There in the search sheet. In the search sheet itself. In the search sheet
I
itself.
believe you, but still then we need to call from the court.
Okay, I'll withdraw the case. I'll withdraw.
You'll file application before the,
I'll file before a trial court.
that will be better, always better. How long he has been inside?
He has been arrested on 34.
34 days.
2025.
Then I think, okay, charge is filed. But then still then, it will be better if you file.
He has been arrested on 34 2025.
Okay, charge
And
is
now
filed
we have seen the
before
gravity of the
before
section.
expiry of the statutory period.
Yes.
Gravity of the section also.
Okay.
You have seen that it is only 2 years.
You'll be, since you will be granted bail by the trial court only.
And
Why
it
is it
was to be the session court. It was more
Right,
bail petition was more.
okay,
He was not given
okay,
the bail only on the ground that 111 and the other unlawful activities section 13. Considering the gravity of those sections, the bail was taken.
You're right. you'll be the right person to decide. the
Yes,
bail,
there
no?
is a
Okay.
better position.
Learning Council, Mr. Mukpati, assisted by Mr. Mukbom, but Learning Council for the petitioner want to withdraw this bail petition with liberty to file a press before the appropriate court. Prayer is allowed. This bail petition is dismissed on withdrawal with liberty as prayed for.
It's a bail hearing.
Item? Why? Not Mr.
Mayor, please.
Supplementary code, yeah? Yeah, okay. Yes.
My lord, here certain necessary correction may be given because here earlier occasion matter was taken up by the December court and next date was supposed to be listed after 4 weeks. But here in this case, this is a POXO matter. So complainant victim had to get the opportunity to appear before the December court. Here, no specific date is given. So therefore, I prayed before the December court to fixing a next date with the party date so that the respondent victim may also appear. So I propose to fix it again by 25 and the concerned OCPS may be directed to serve the service copy.
It was served, the notice was issued.
The notice is issued, but I have impaired the issue process. There was no such exact,
The date for appearance,
yes,
their appearance.
and it will difficult for the other party.
Okay.
The concerned
So can
OCPS
we
is,
fix 25?
yes, I am proposing for
Whether
25.
the notice will reach to the respondent by then,
We have already taken the step.
then unless you indicate the date.
So definitely it could
You
be.
said that since date was not indicated, it was difficult. And if we indicate today, will it, then again, you will have to again inform the parties that it has to be, you are to appear on 25th. Can it be?
It will be, yes, it can be.
Okay.
Because
Whether
after,
record was also
26th
called for?
court will vacation, so it will difficult for me.
Whether record was also called for? This is bail.
Only CD. CD
CD.
was called, yes.
CD, have we received?
No, no, sir, not yet.
Okay. Mr. T. Thorum, non-counsel for the petitioner. Also had Miss L. Hagen, an additional PP, who prays for some more to produce the scanned copy of the case diary.
Updated case diary last week.
Hmm?
This can copy of updated case diary.
Okay. Okay. As prayed for, comma. This is matter again on 25. 25th,
Yes, not today.
will you be able to take?
Today itself, I will take a step.
Okay,
So it will go to the office of PP also
okay.
Yes.
because of POXO
Okay.
matter.
This is matter again on the petitioner shall serve notice upon the respondent number 2 through the office of the learned public prosecutor. Respondent two is a victim.
Complainant father.
Okay, complainant victim, huh? Respondent number 2 stroke complainant victim. So Office of the Learned Public Prosecutor. So the officer in charge of concerned police station. Okay. On which date the learned additional people shall also produce the updated case diary. Okay.
Yeah.
Okay.
Item number 12.
My lord, in this matters, service has been completed.
Okay.
So matter may be fixed for admission hearing.
Okay. Heard Mr. Pitapo, learned counsel for the petitioner. Also, Ms. El Hage, learned counsel appearing on behalf of the state respondent. Since the parties are duly represented and the trial to record has also been received, let the matter be listed for admission after 3 weeks.
After
3 weeks.
yes, ma'am.
Okay.
Obliged.
Item number 13.
Yes.
May your lordship.
Hmm.
Your lordship, here there are 14 respondents. Service report in respect to the respondent 1 to 7 and 9 to 14 is completed. The lefty service report in respect of respondent number 8 is still awaited. Your lordship.
Ms.
M. Zora.
Learned counsel for the petitioner is present. This is item
Item 13.
13. The service of notice upon the respondent number 8
Yes,
is still awaited.
it's still awaited.
Okay. In view of the above, let this matter be listed after 2 weeks.
After this puja break,
Okay.
your
After 3
lordship,
weeks.
there is an interim.
Hmm?
There is an interim.
After the entering puja vacation stop. The interim order passed earlier shall continue till the next date of listing of
Obliged.
Item number 14.
yes. None appears on behalf of the parties on call. You are, none appears on behalf of the petitioner on call. Mr. G. Tadar, learned additional people is present on behalf of the state respondent. In absence of the representation on the petitioner side, the matter stands.
Reference report was there.
Hmm?
There in the record.
What?
This matter was kept for a reference.
Kept for?
Reference. That whether there the due to the first layer of the 2023 any application or any matter after beyond the reference number 1 of 2024. It is a record.
What is this matter? Criminal petition for what?
It's only for disposal.
Only for washing petition?
Yes. It's for passing the complaint of NI case. And it is well settled also.
Okay.
In page number.
None appears on behalf of the petitioner on call. The record reveals that on that the petitioner remain unrepresented on 3/2/2025 on several occasions, including on 3/2/2025, 24/4/2025, today also, when a matter was called, the petitioner remained absent. In view of the above, it appears that the petitioner is no longer interested to pursue with the matter any further. It appears now. Okay, in view of the above, this criminal petition is disposed sorry, dismissed for non-prejudice.
On report.
Okay.
Yes, on report.
Yes.
Item number 15.
Yes.
Your Lordship, I'm appearing for the respondent wife.
Respondent
Wife. So
one
I may be given some time to file affidavit in opposition.
appearing for the first time.
Yes, Your Lordship.
Okay. Okay, Mr. Aringolani, counsel for the petitioner is present. Miss
L. Mariam.
N.
Mariam.
Morgan Lani, counsel. L. Moriam.
Yes.
Okay, L. Moriam, Lani, counsel. Would appear on behalf of the, how many respondents?
Only one.
Okay, on behalf of the sole respondent, you have filed wakalatnama.
Yes, sure.
By filing wakalatnama and prays for some time to file.
I think today is the second
Second.
appearance. Yes.
This is my first appearance, Your Lordship.
There is no
Filed
record.
on 2,
Okay,
2025.
no, it is better to record her appearance. Nowhere recorded, huh? Only first and thereafter
31/5/2025.
31.
Yeah.
31/5.
They have already entered their appearance.
J.
Yeah.
There is no order on 31. 36, where it says due to paucity of time, it could not be taken up. No name of the advocate. Not yet come. Okay, so it's better.
No, it's good.
Okay, and prays for some time to file. You want to file objection or what? File response if necessary. The prayer is allowed. List this matter after 3 weeks. Okay.
Interim is there. Interim.
The interim order passed earlier shall continue till the next date of listing. Okay.
Item number 16.
Yes.
Lordship, I mean, appearing on behalf of C.
Appearing on behalf of C.
Hearing.
Okay, for the petitioner.
Yes, this matter may be kindly used for admission here.
For
Admission hearing.
admission.
Service completed, Lordship.
Service complete. Okay, since whether the record was called for, any trial court record was necessary or called for?
Lordship, if they have already annexed, Lordship,
Hmm?
they have already
Not
annexed the
necessary.
order, Lordship. No, not necessary, Lordship. Because they have challenged the order, Lordship.
Mr. Iran, Lani counsel for the petitioner, and Ms. Ilhaje, Lani counsel, the Lani additional committee are present. Since the parties are duly represented, let this matter be listed for admission after 3 weeks. Okay.
Lovely.
17.
Yes.
Lordship, this matter may be listed for vacation.
After vacation. This criminal petition for what? This quashing petition?
Yes, my lord. On settlement, my lord.
Settlement?
Yes.
You have objection?
No objection, my lord. They already there is an stay by this honorable court, my lord.
Stay.
Yes, stay is there.
Okay. What is this?
The sections involved is 324, 427, and 34. And non-compliant offense is 324.
324.
Yes.
Can be.
Yes, ma'am.
Okay. So what is the status of the trial? Is before the court?
Yes, my lord. The charge sheet was filed, and
Have they mentioned GR case number? Which court?
GR case number, my lord,
Yes,
is there.
GR case number is
Yes,
there.
is there. Yes, my lord.
And which court? Pending before the court?
Chief Judicial Magistrate,
Chief
0, my
Judicial
lord.
Magistrate, 0.
Yes. Now trial already commenced, my lord. It's for prosecution witness, my lord.
Okay.
Examine prosecution witness.
So the
Evidence stage, my lord. Your Lordship will find in the page number
It's a
151.
joint petition.
Yes, my lord. Your Lordship,
Okay. There is an agreement also.
yes, my lord.
They don't want to pursue.
Total 15 petitioners, including the victim.
Hmm.
And their settlement is in page number
Hmm.
150,
150,
152, my lord.
52.
Yes.
Yes. Let us see if the all the required documents are present. Okay, heard Mr. Giram, learned counsel for the petitioner. Heard Mr. K.A.K., learned additional PP for the state. This is a joint application filed by joint petition filed under section 528 of the BNSS 2023. Praying for setting aside and quashing the GR case number 47 of 2022 arising out of Raga PS case number 15 2022 under section 324 427 34 IPC and before the Line Court of Chief Judicial Magistrate 0 Lower Suburban District 0. Stop the para. The petitioner, who is the informant? Where do we find the complaint?
The name of
The FIR. Who is the
FIR
how
is in
many,
my FIR is in page 78, my lord. Type copy
78
my lord. Yes, type copy.
following list of the informant is only one.
Yes, my lord.
Okay,
Ine
then
Tapar.
which one is the informant? Ina. Ina is at serial number
Inner, my lord. Inner is serial number 14.
Petitioner number 14.
okay. The
14 number.
petitioner number 14 is the informant, and the petitioner number 1 to 13
Yes, my lord.
are the accused.
1 to 15, my lord.
15.
1 to 15 except 14, my lord.
Okay. 1
15 is victim, my lord.
1 to 12. 1 to 13
1 to
and
13.
15.
Yeah, 1 to 13 is accused. 13 is accused. 14 is informant. And 15 is victim.
Oh, 15 is victim.
Yes, my
okay.
lord.
The petitioner number 14 is the informant and semicolon. The petitioner number 15 is the victim, and the petitioner number 1 to 13 are the accused in the above GR case number 722 arising out of Raga PS case number 15 2022. The prosecution case is that on 18/7/2022, the petitioner number 14 lodged a written FIR before the officer in charge police station Raga against accused petitioner number 1 to 13. For physical assault and snatching away the personal belongings and breaking of the gun of the victim. Stop based on the above written FIR, the above Raga PS case number 47 2022 was registered under section 34, 427 and 34 IPC and investigated into staff. Upon completion of investigation, the police has submitted the case into charge sheet under the same offense Stop. The learned Chief Judicial Magistrate 0 has taken cognizance of and the matter is on a trial before the state court. Stop. Para. It is submitted that during the pendency of the trial of the above case, informant, victim, and the accused have amicably resolved the matter by executing deed of mutual settlement agreement dated 24/2/2025. Start. According to the mutual, the deed of settlement, the FIR was lodged against accused petitioners number 1 to 13 due to misunderstanding. Due to some serious misunderstanding regarding boundary pillars. However, boundary pillars leading to pushing and pulling between the parties, resulting filing of charge sheet against the accused persons. However, since the matter has amicably been settled between the parties, the informant and the victim have no further grievances against the accused persons and does not want to pursue with the matter any further. The parties are also relative to each other. No, are also close. The parties are also close. The close relatives. And therefore, in order to maintain their matrimonial relationship, the informant and the victim has undertaken to cooperate with the petitioner for filing appropriate application before appropriate court for quashing of the case against the accused persons. Stop. The learned counsel for the petitioner submits that since the case has amicably been settled between the parties and there is no grievances against each other, the further proceeding of the case would only result into only cause unnecessary harassment to the parties and an abuse of the process of law. Start. Para. And therefore, sorry, not para, and therefore pray for setting aside the proceedings against accused before the learned Chief Judicial Magistrate Court. Stop. that Mr. A, the learned additional PP, fairly submitted in view of the amicable settlement between the parties. And in order, between the parties, in order to maintain their matrimonial relationship, he has no objection if the prayer of the petitioner is allowed. Okay, then I'll
Deeply obliged, Your Lordship.
Item number 18.
My lord, in this also the service upon respondent two is complete, my lord. I'm seeing Mr. M. Bhatt's name is there in the. Oh,
Okay. Mr. Peter, Post Planning Council for the petitioner is present.
you're appearing, or he's appearing for the respondent.
Okay, and Mr.
Yes,
And then, okay, Mr. L. Hage, Lanet additional PP for the state, and Mr.
yes,
S. M. S. M. Spelling
SING.
S. I. Oh, Singh. Okay. For the respondent number two are also present. Since the parties are duly represented, whether the court was called for? Necessary?
No, it's not necessary.
Not necessary. Okay. Parties are duly represented. Let this matter be listed for admission after 3 weeks. Yes.
Lordship, may I, Lordship? And the item number 16, Lordship, it is already over, Lordship. Let the LCR, scan copy of the LCR may be called for, TCR may be called for, because there was no interim, Lordship. So it may be called for, Lordship.
Okay.
Item number
The-
16.
Okay. It is submitted that the trial court record would be necessary for proper adjudication case. Okay. Therefore, and let the trial court record be called for.
Scan copy, Lordship.
Scan copy of
Yes,
the trial court record. Okay.
Item number 16, Lordship.
Yes, 16.
Obliged.
Item number 19.
Lordship, item number 19, the TCR is yet to be received, Your Lordship. There is a there is a notice, letter, Your Lordship, addressed to this honorable court that the records in the CGM court has been transferred to JMFC. So records may be called from JMFCU.
Item 9.
19.
My lord, Mr. M. Doji. Yes, Planning Council for the petitioner is present. What?
I was supposed to take steps on respondent number 2, man.
Okay, you are, Mr. Doji, Planning Council for the petitioner, press for further 1 week time to take steps upon the respondent number 2. Respondent number 2, this is criminal petition.
Yes, man.
Okay, the prayer is allowed. Steps upon the respondent number 2 by a registered post with AD.
Yes, man.
As well as by usual process within a week from today. So, in the meantime, the Miss Jeannie Lana additional PP submits that the record of the case has been already transferred from Chief Judicial Magistrate Court to the Judicial Magistrate First Class UPR.
Yes, Your Lord.
Okay. And submits that the record would be necessary. Call for the trial court record from the Chief Judicial Magistrate First, scan copy of the trial court record from the Judicial Magistrate First Class. Okay.
Yes.
List this matter after 3 weeks. Yes.
Deeply.
All right.
Item number 25.
It's on the list. It is a last matter for today.
Yeah.
Last time on 9/9/25, learned amicus curiae was present. So that's why. But
It's not here in the, not here. It's there only. There it is. I could see. So, but
this,
who is for the petition?
this is only the
Appellant, you are for the appellant, are ready for hearing.
Lordship, I am for the respondent victim,
Then,
Lordship.
but appellant remain absent, amicus.
Lordship, appellant is the amicus.
So what to do?
his almost appellant submission. He admits and he compensates also
Okay.
to the victim lady. He shows the gun shot. Under 307, read with section 25, 1B of the Arms Act. This,
Is it death case or injury?
this is a case whereby appellant has already admitted his guilt.
That is why he was sentenced.
Is in custody and released on bail. Conviction. 10 years.
10 years.
Yes, for committing an rigorous 10 years rigorous delivered on 20th day of December 2021. That means now it is 2025. Almost 4 years have been elapsed. No, on last occasion, Learned Amicus Query already submitted his point. Uh, 164 is at paperbook page number.
Okay, paperwork is there.
Yes. Paperbook 164, page 16.
Okay, so let him be present. We'll fix it on Monday or Tuesday. Let him be present. Okay. Just pointed out few points. This court will ask, and then so that we record the presence of the amicus and presence of the legal aid counsels also. Only after recording, we need to record as heard. Okay. Mr. Okay. Amicus for appellant. Okay, Mr. Tato, Planet additional PP for the state. Mr. Jungam Jini and legal aid counsel are present. In absence of appellant. We'll continue at 2. How many are? One. Only one. Or is it a long matter?
Frankly, it will take some time.
Okay. That's fine. Why don't we list it on Monday then?
On Monday, judgment will be passed. That's the problem. Otherwise, I have insisted. Without hearing the
My lord, actually, the matter I have gone through the record also, my lord. The issue is no more res integra. This court has already settled the issue. But the learned, special court, your lordship, is not complying with the judgment of this honorable court, which has been passed earlier. Just to, your lordship, see the record, whether the honorable trial court has complied with the judgment, which has been placed before the court by the council. That has to be just appreciated, my lord. Because the proceeding is almost complete, but the only issue is they have raised an issue for determination of age. Now it is well settled that any stage it can be raised. When it is raised, the court is POCSO court is bound under section 34, read with 94, to first determine the age, then proceed further with the case. So that part is, your lordship, not that part is not
Whether
done.
this court or any directed?
No.
In this case,
Not
directed.
in this
Only the
case, it
court.
was not
The
directed, but
judgments are there.
the other case, my lord, similar situated case, same situation, my lord.
Okay.
There is a judgment from this court, my lord.
So this is fixed for the hearing also done?
No, that's the problem, ma'am. Otherwise, I wouldn't have insisted.
No. Before the trial court?
No, hearing, my lord.
No, how you, on what basis you are saying that the order will be passed on
My
Monday?
lord, these orders are there for final judgment, ma'am.
No, that is why I'm saying, but for final judgment, hearing has to be done. Whether hearing have been,
No, not done. That's why I'm submitting.
how
my
the
lord.
judgment?
No, Your lordship, that's why I kept come before your lordship, my lord, without hearing, my lord, how judgment can be fixed.
It's fixed for judgment.
Yes.
You have annexed a copy.
Yeah, I have the copy.
It's clear, my lord. My lord has to just appreciate the record. The orders are there. They are sequentially my lord, order. And there was one miscase for determination of age. And this court has settled this issue. That when the determination of age is assailed before the court for the first time, it is the duty bound of the court to first settle the issue, determine the age, then proceed with the main case. So here, in this case, the learned session or special court ought to have determined the age first, then proceed with the final hearing of the case. That was not done, my lord.
Okay.
Top of that, hearing also was not done. In a fixed for judgment on Monday.
Then probably it will take around half.
Half an hour, hardly half an hour, my lord. The law is very clear now. If law was not clear, then it will be different. Law is clear now.
We'll take away 2 then.
Yes, sir.
Item number 27, unlisted motion matter.
My lord, before starting the proceeding, my lord, may just so to show that, my lord, because we don't have the order of 22/8/2025, my lord. That's why I'm just the matter is filed for judgment, my lord. This e-court, my lord, from the e-court portal we have downloaded this. The first itself, my lord, first page itself, your lordship will see the case number and
It's for judgment.
yes, ma'am.
See, normally in such cases, what the judges do is in the judgment itself, because initially the first issue is to whether the age of the victim.
Yes. Yes.
Probably they are bound to discuss and then decide the issues, age of the victim first. Thereafter only whether the POCSO Act attract or not.
Yes. That's exactly what we are saying, you know.
So now in a judgment itself used to be there.
My lord,
If there is an evidence
No, my lord, what?
In the case of the accused,
Yes.
of course, it has to be, of course, decided whether it will proceed. Of course, as per the provision that is there, but then that is there, of course, not only for the accused, but then for victim also.
Yes.
That is there under 94. But
Yes.
in the judgment itself, the judge is bound to discuss and decide the issues.
Yes.
Regarding the age of the victim.
Now, my lord, here what happened, my lord? The trial was completed, my lord. 313, everything recorded. Then we, my lord, somehow got hold of the birth certificate which was provided by the hospital, my lord, where she was, the alleged victim was born. This is my lord, a case where this alleged molestation, my lord, outraging of molestation.
When the incident took place?
My lord, this of cases of 2019, my lord.
2019. Yes. So why you have come now? Because judgment is due for the day after tomorrow, as or Monday. Why today?
Because, my lord,
and this order was passed on
last transaction of 16, my lord.
Last order of 16/8.
Yes, 16/9.
16/9.
Yes.
Oh.
We did not, we applied for certified copy of that, my lord, proceeding. But we also applied for the proceeding of 22/8/2025, my lord. We didn't get that.
16/9.
Yes, my lord.
This was for, fixed for what?
16/9, my lord, we thought, my lord, our miss case would be disposed of. We filed 2 applications, man.
Earlier.
Yes.
First, it is still pending according to you.
Yes. Because nowhere it has been disposed.
Was it whether the trial court has indicated that it will be disposed of along with the main case?
No.
Not yet disposed of.
No. If we
then probably
if your lordship sees
it is in his knowledge only.
Yes, we file application first of all when we during the trial also when we got hold of the documents, this was brought and cross-examined. It was exhibited. Now we file an application based on, first of all, my lord, the certificate from the medical where she was born. That certificate and her earlier school admission and certificate.
But then this was seized at the time of.
No, this was when the trial was completed. We got hold of those, my lord. Then only we file an application saying
2019 case.
Yes.
When this application was filed, you said?
Your lordship may kindly, that was the, first of all, yes, page 84, my lord.
It was 25 only.
Yes, ma'am. In the April. Here, what we are saying, my lord,
no order was passed here.
No. Some orders are there. I'll show you, lordship. The orders were passed. Well, if you, lordship, first of all, sees the page 25, the order that was passed on 1/7/2025. Lordship got it, man.
Yes.
Now, my lord, we see, fix the case on 22/8/2025 for hearing on final argument, man.
Taken on record.
Yes.
Certificate.
Yes.
Certificate for hearing on final Okay, taken on record only.
No,
This was
this was not produced by us,
produced by whom then?
by the prosecution. That time prosecution produced, madam.
And then in this application, no order was passed.
No.
Whether this matter was listed before the court is your miscase?
It was there, but it was never heard, madam.
No, whether it was listed?
Yes, it was there.
It was listed.
Yes.
So in the main order on this day, when this was listed, what
Yes.
order was passed?
Your lordship will kindly see it was 16/9/2025.
16/9, 2000. Where do we find?
Page 26. But this was regarding this only was listed.
Miscellaneous application was listed?
Yes.
Serial number?
6, man. Ogum Tayangdi is the petition.
Serial number 6?
Yes. Page
Okay.
26, lordship.
26.
Yes. Cost list.
Ogum time. Spare was Ogum time.
Yes.
Motion. So no order was passed?
No. This is here in this application what we said, my lord. Because, my lord, the documents which we have annexed, which we have produced in the application, my lord, that what happens, your lordship is aware when the child is born, when it's class 12, parents, they definitely, my lord, they reduce the age. Then if the victim is not called for, if we will not press if the victim is not called for, at least the father ought to have been called for. Here what we said, but the father should be called.
Yes. See, your application was filed 25 only.
Yes, ma'am.
At the last moment, if you file such application like today, when you says that judgment is going to pass on Monday, and today you file application, definitely it is going to going to hurt the judge. What is your intention at the last day?
No, not last day. April, my lord, I have seen the application is filed in the April, first application. This
Listed on
application filed in 2025. Yeah.
It was never listed.
No, it was this 197 was listed on 16/9, and we
No, this 122.
no, my lord.
197 means which one?
No. It was never listed, but there is an order, my lord. There is an order, my lord, referring to all those things, because I cannot suppress anything, my lord. I have annexed.
Yes.
Also.
Where is order?
Your lordship will kindly see that order is of 16/6, page 91, man. Here the miss case was not listed. Lordship will kindly take para 13, man. Above it has discussed everything, man.
Just Birth of, the date of birth of the victim is mentioned as 2001.
Yes.
Education. The date of birth of the victim is 3/5/2002.
Yes. If it is, but if age is taken as 2001, the alleged victim would be more than 18 years.
Then if it is taken on 3/5/2002,
Then she will be minor. Lordship, kindly see para 3 also, it's the class 10 certificate was also not furnished.
Just a minute. Yes, not- Okay. Para, which you say?
No, my Lordship will kindly see from para 13, ma'am.
For 13?
Yes,
Oh,
page
this is
95.
No order.
Yes, ma'am. Para 13.
Oh.
Your Lordship has seen para 3 and all that, the class 10 mark certificate was, class 10 certificate was not produced, madam. It's admitted. Now para 13, madam. This will come. It is the plea of the defense that documents produced by the prosecution that any card is not a document which is to be relied for age determination. It's further submitted a birth certificate which was not served on defendants along with charge sheet cannot be relied on for determination of age. It is prayed by learned counsel for the defense that the age of victim be determined before hearing on final argument. In view of the above submissions made by learned counsel for defense and in view of the law for time being in the force, prosecution directed to produce the appropriate documents for determination of age of victim as provided under section 94 of JJ Act. Let a copy of this order be forwarded to OCPS for production of age proof document of the victim as provided section 94 JJ Act as prayed for by learned counsel for the accused fixed case on 17 for producing. It's not accused, it should have been prosecution. Original birth certificate, class 10 pass certificate, or ossification test report a victim for hearing of age determination of the victim. Now, Lordship has seen, we have disputed the age, which is very clear from this order
So
itself.
then what happened on page now?
Now, my lord,
117.
Lordship, I have just page 25, I already showed to your
Okay.
Lordship. Page 25.
Page 25.
Lordship got it. Now, today, present case is fixed for appearance of accused person and for production of original birth certificate, class 10 pass certificate, or ossification test report for victim for hearing on age determined victim. Accused Ogam Tang's absent with steps. His learned counsel is present. State is represented by such and such. Victim informs presented by learned such and such. As directed, original class 10 certificate, pass certificate victim produced, which is taken into account. Fix the case of 22-8 for hearing of the final argument. Whereas no determination was done. That's the crux of our argument. Everything was before the learned court.
So, according to you, since it was not determined,
yes,
it should be determined before
but
the judgment.
It must be determined first, my lord. Since April is matter is pending, my lord.
So the provision says that under 94 and then this 34.
No, but
says that
Honorable Supreme Court says, my lord,
it should be determined first.
yes,
The first order is to be passed on the
yes, our own High Court judgment is there. In that regard. My lord, may kindly appreciate how the matter would differ, my lord. Once the age is determined, my lord, this section would definitely go away, my lord. Why not, for safety's sake, determine the age first, then go for the final?
Because if the age is disputed, if raised also, if there is an evidence,
that
in the judgment itself, it is discussed and age.
First of all,
but then here is the case where the court.
There must be evidence laid by the parties to determine, because we have produced the documents. Now it's our turn to adduce evidence to prove that those documents.
It is to be determined under which section? 34.
Yes, 34 of POCSO Act.
So hearing done for the entire case.
No.
No, hearing also not done.
It was fixed on 22, madam.
Okay, where is
your lordship is already in page 25 itself.
Where is 22's order?
Yes, no, madam, page 25 itself they written. Fix the case on 22/8/2025 for hearing on final argument.
See, where is the where is the order? 22/8/2025. What order was passed?
We don't know, because we applied for certified copy of those one.
No one represented you on 22.
What happened, my lord? On 22nd, the previous counsel, he did not continue with the case. a new counsel was engaged in this matter. He sought time for an argument. There was no argument on 22nd. Therefore, we
No, still then you have not obtained the order.
no,
22-8, way back in 22-8, it was passed. What is the last order? Would like to
no, we
see.
didn't get, but we have certified applied for certified
Oh, Learned Council, way back in
page 29. We didn't get judgment. That was the registry 29, our application for certified. But when the certificate copy is not being provided, we are helpless. The main counsel who was dealing with the case,
he has no knowledge what order was
no,
passed.
a new counsel was there. He sought for adjournment on the 22nd. And we don't know what order has been passed. Therefore, we applied for certified copy, but certified copy also we are not provided.
That order is necessary.
Whether our application has been rejected on that 22/8/2025 or not, that also we don't.
Yes, sir.
The apex court has settled the
Where is that?
our apex court judgment.
In what case? Case between?
This is not related to POXO, but it's related to how we should go about. The Honorable Apex Court has
Not in POXO case?
no, but
How it regarding age?
yes, how
What case?
now how the age should be determined. The guidelines has been provided by the Apex Court. This is in case of Rishpal Singh Solanki, madam, was state of Uttar Pradesh and others. So, madam, the rest I wouldn't not only para 29, madam.
29.
Yes, but it's down below 24 of 31, but from page 24 of 31. Page is down right side corner, madam.
What emerges?
Yes, what emerges on because everything was considered by Supreme Court, all the previous judgments and all that, madam. Then ultimately this judgment was passed. What emerges on community considered opposite pattern of judgment is as follows. A claim of juvenility may be raised at any stage of criminal proceeding, even after a final disposal of the case. A delay in raising the claim of juvenility cannot be a ground for rejection of such claim.
This is in respect of accused, okay. Then
Yes. And an application claiming juvenile could be made either before the court or the JG court.
okay, this is also for
Yes.
accused.
When an issue juvenile arrest before, it would be under subsection 2,
Okay,
3, and all that. And
where it comes for the victim also? Where it is mentioned?
Madam, here the main context is how the juvenility should be determined. This is the crux, madam. So, madam, when the accused is there,
Where anywhere mentioned regarding that juvenile,
here victim is not mentioned.
the victim's age should also be determined.
No, that victim,
Age in the case of the juvenility.
victims,
Case of the
that
accused.
judgment is passed by our own High Court.
Yes, where is that?
State will provide, my lord. State will itself provide. My lord will find in JJB Act rule, my lord. Rule 5418 subclause 4. What is it?
JJB rule?
JJB Act, my lord.
Act.
Yes, my lord. Rule 54, my lord. Rule 54.
JJB rule?
Yes, JJB Juvenile Justice Care and Protection Model Rule 2016, my lord.
Okay.
Rule 54, my lord.
Page,
my lord, 1, my lord, page.
Page would be different, my lord.
One. If it is the same. Just a minute.
My lord, yes,
It
my lord.
starts from.
54, procedure in case of offense against
Just a minute. Adoption.
Chapter 8,
Lesson. Care and protection. Yes.
Rules in the rules.
Just a minute. Let me just. Rules. Okay. Section 54.
54, Rule 54, my lord.
Okay. Procedure.
Yes.
Case of offense against the.
Yes. My lord may come.
Procedure in case of offenses against.
It's a general.
Children,
Children, whether it's accused or
just a minute. 140.
Now, my lord may come to 18. Sub rule.
Just a minute. Offense against children. 18.
Yes, sub rule 18 and then sub clause 4. Roman 4.
This is 24. 18.
18. Then your lordship,
Yes,
18 sub rule.
okay, 18.
Sub rule 4, Roman 4.
4.
Yes.
Okay, yes. For the age.
Determine of the victim in relation to offense against children under the Act. The same procedure mandated for the board and the committee under Section 94.
For the age determination of the victim in relation to offense against children. What is section 94? How do we know? Can we just read once?
Yes, sir. Section 94, your lordship, there it provides the document. What document can be relied upon? Which documents are admissible?
These
How
are
to
those
determine?
3 documents.
Yes, determination, presumption and determination of age, Section 94. Here, your lordship, the hierarchy of document has been given.
Yeah.
And in presence of this document, my lord, if class 10 certificate is there, my lord, and if they are assailing, then they must be given an opportunity to rebut the same, my lord. Your lordship, so far as reciprocal Solanki case is concerned, my lord, here your lordship will find in subsection 2, 94 subsection 2, my lord.
Yes.
In case the committee or the board has reasonable ground for doubt regarding whether the person brought before it is a child or not, the committee or the board, as case may be, shall undertake the process of age determination by seeking evidence, yes, by obtaining. So first, for presumption, my lord, either of these documents must be there. If date of birth certificate is there, there is no necessary to look for the matriculation. If matriculation is there, there is no necessary to look for the other. But presumption will draw by the court, and the party who is rebutting this, who is assailing it, they have to rebut it, madam, by adducing evidence, madam.
So here in the present case,
Yes,
as per the prosecution, there one is fulfilled.
Yes, my lord. That matriculation certificate is now there.
Yeah.
Now they are disputing it, my lord. Disputing in the sense they are disputing the age, my lord.
Fine, if they dispute, what is the procedure then?
My lord, that procedure,
Because the first condition they have fulfilled.
yes, my lord. My lord, now my lord will come to the reciprocal Solanki case, my lord. Their Supreme Court has said, if matriculation, if any of the document which is specified in Section 94 is produced, that on basis of that the presumption will be drawn. And the other side, who is assailing it, who is disputing, they have to disprove the same, rebut the same. Your lordship may come to the reciprocal Solanki case again, my lord.
Where is I've already given, madam.
This one?
My lord, yeah, this is the STC one, my lord. Paragraph would be very. STC, that is
same, but the same.
paragraph will be very, my lord, because In my judgment, it's para 33. Same judgment, my lord, but the journal is different, my lord.
Yes,
My lord may come to 33.3 in the judgment.
yes. 33.3, okay.
33 point, my lord, the same guidelines, but here in the SCC, SCC,
Well,
it is
see.
33.3.
Hmm.
That when a claim of juvenility is raised, the burden is on the person raising the claim to satisfy the court to discharge the initial burden. However, the document mentioned in Rule 12(3)(a)(1), 2, and 3 of JJB Rule 2007, made under Section JJB Act 2000 or subsection 2 of 94 of JJB Act, shall be sufficient for prima facie satisfaction of the court. On the basis of aforesaid document, a presumption of juvenility may be raised. Presumption will be drawn, my lord. It will not be an absolute, my lord. The party must be given an opportunity to, your lordship, discard the credibility of the document, and prosecution is accordingly, prosecution has to protect their case, your lordship.
So you mean to say that since they have raised,
Yes, my lord.
although the condition on 94 to I has been fulfilled, but then since they have raised,
Yes, my lord.
they should be given an opportunity.
Yes, absolutely, my lord. Otherwise, my lord, the trial will be like this, my lord. If somebody produce class 10 document, whether it's maybe forged, whether somebody may have increased or decreased her age, his or her age, then your lordship, if it is considered as an absolute, it will cause prejudice to the either victim or to the accused who is in the other side, my lord.
Whether accused is inside the custody?
No.
Okay.
My lord, before production of the class 10 certificate, we had already filed an application for determination of the age, my lord.
And my lord, here,
That's the
2025.
yes,
in
my
the last moment.
yes.
and my lord,
Before
here,
that, we had filed our application, my lord.
here, your lordship, one of the important order would be the 22nd/8/2025 order, my lord.
Hmm?
That order which they have applied, perhaps they have not received it, the certified copy.
Mhm.
So that order is also order has to be looked into.
Yes, that
But-
is why I'm saying.
Yes, but still, my lord, if we see to the one, my lord,
After that only the judgment.
yes, my lord, now I will come to the, my lord, the stage, under what stage it has to be considered. Now we have seen how is to be considered, how it is to be considered. But now I will, your lordship, apprise to the court, because your lordship, it's a matter of, it will have impact on every trial if if I make a wrong submission. So my lord, the stage, now Supreme Court is very clear, there is no any question of delay. No, the court cannot say that, no, you ought to have come at the very first stage during the CC or during the investigation. No, my lord. Here is a case from the Manipur High Court, which has been rendered by the justice now in the Supreme Court judge, Koteshwar Singh. Here also, my lord, here is a case. There at the stage before framing of charge, age was claimed, determination of age was claimed. There, the other side has objected that it can be considered after framing of charge, because the trial will be commenced.
No.
But
That cannot be.
yes, but the court has held that no, as and when it has been raised, it has to be determined first.
Yes.
Then accordingly, before framing of charge, my lord, the age was direction for determination of age was given.
That is at the right stage.
Yes, and then, my lord, the second part is before our own High Court, that Pitam Lamio case, my lord. Now his conviction has been upheld by our own court. There also, my lord, at the stage of final hearing, my lord, they have claimed for age determination. Then court is rejected. No, the age will be determined along with the this main case, my lord. The judgment, as your lordship has indicated, in the final judgment, first the issue here normally.
Yes, the first issue is
First issue.
regarding the age only.
Yes, but my lord, in that case also, after considering the Supreme Court judgment and this Manipur judgment was mostly referred by this our own coordinate bench. There, your lordship, also the court find that the age will directly go to the core of the case, my lord, because it will directly have the core on the jurisdiction.
The seriousness is crucial.
Yes, yes.
But what I'm saying, it is the question or case of the accused or juvenile.
Yes.
Then definitely it has to be immediately. But then since it is a case where the age was already there.
Yes,
But
madam.
then subsequently he has raised this disputing the age.
Yes, madam.
Certificate which was seized, which
Yes.
was executed.
Yes.
Exhibited.
Yes, madam.
Now this at the moment, of course, the last order is necessary,
Yes, ma'am.
what he has stated there. What
Yes,
he has
exactly. What order he was passed, it
what
was
order
passed, yes.
he has passed. So that is of course crucial.
Yes.
If there he must have indicated.
Yes.
If not indicated, then he is bound to indicate it otherwise.
Yes,
Because
absolutely,
there is
madam.
application.
Now, madam-
Application not yet disposed of.
My lord, for my satisfaction, my lord, may kindly peruse these two judgments of our High Court, madam.
Yes.
The first one, wherein the direction was given, the second one.
In the what I was trying to say,
Yes,
is
ma'am.
that in the case of the victim,
Yes, my lord.
the judge is bound to discuss the age of the victim.
Yes, my lord.
That is the first and foremost issues
Yes, my lord.
to be decided.
But victim or accused, my lord?
No, victim.
Here also victim.
Accused, age of the accused cannot be decided. Age of the accused has to be decided before framing of charge, or
Yes.
just in that case, you cannot proceed
Yes, my lord.
without determining the age.
Yes.
But in the case of the victim, it can be decided even after
The conviction.
even after the argument also.
Yes, my lord.
At the time of in the judgment, it will cover.
Yes, my lord. My lord, the act
Mostly
says,
it has been
the
done.
act has kept both accused and the victim in conflict with
So
law
now this, of course,
in the same, your lordship, in the same place, my lord. No distinction has been given by the, your lordship, the statute, that no, victim examination has to be done in this stage or accused examination has to be done in this stage. The statute says, as and when the age for determining the age is raised by the either of the party, it is the duty bound for the court to decide it. Because, your lordship, we have to read section 34 of the POCSO Act also, my lord. There also, my lord, actually for determining the age, the special court has to exercise the section 34 subsection to read with section 94 of the JJB Act, my lord. Now, your lordship, I'm just referring to this judgment because even in this judgment, my lord, at the stage of final argument, my lord, they have challenged. Yes, my lord. Para, my lord, from 6, my lord, I will read out, my lord.
yes.
I heard the submission made by the learned counsel for the parties and also peruse the provision referred to herein above. On bare perusal of section 34(2) of POCSO Act 2012, it provides that if any question arises in any proceeding before the special court, whether a person is a child or not, such question shall be determined by the special court after satisfying itself about the age of such person.
This is para 6.
After para 7, now para 7. Yes, my lord. My lord, the first, my lord, first one is the reported.
Para 7, maybe. Which para?
My lord, this one, I have given you two judgments, my lord. This first.
Okay.
Oh, that one, the second one. Para 6 onward, my lord. Okay.
Yes.
Yes, my lord, para 7.
This is same party.
Same party, my lord. After this order, again the court has not complied with this order. Then your subsequent order was passed. My lord, I will read
Which
this.
one? See, this is subsequent order. Which way?
This is the first judgment, first order. After that, my lord, the subsequent order was passed. I will refer to that on later.
Okay.
7, my lord. On bare reading of section 34(2) of POCSO Act 2012, it provides that if any question arises in any proceeding before the special court, whether a person is a child or not, such question shall be determined by the special court after satisfying itself about the age of such person, and it shall record in writing its reason for such determination. Section 42A of POCSO Act 2012 provides that the provision of the Act shall be in addition to and not in derogation of the provision of any other law for time being in force, and in case of any inconsistency, the provision of the Act shall have overriding effect on the provision of any such law to the extent of inconsistency. Now, say para 9. Section 94 of the Juvenile Justice Care and Protection of Child Act 2015 provides that 1. Where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provision of this Act, other than for the purpose of giving evidence, what the said person is a child, the committee of the board shall record such observation stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as case may be without waiting for further confirmation of the age. Now, 2. In case the committee or the board has reasonable ground for doubting regarding whether the person brought before it is a child or not, the committee or the board, as case may be, shall undertake the process of age determination by seeking evidence by obtaining 1. The date of birth certificate from school or the matriculation or equivalent certificate from the concerned examination board if available, and in absence thereof, the birth certificate given by a corporation or municipality authority or a panchayat. 3. And only in absence of 1 and 2 above, age shall be determined by ossification or any other latest medical age determination test conducted, yes, on order of the committee or the board, provided that such age determined test conduct on the order of the committee or the board shall be complete within 15 days, so and so. 3. The age recorded by the committee or the board to be the age of the person so brought before it shall, for the purpose of this act, be deemed to be true age of that person. 10. The Rule 54. 18(4) of the Juvenile Act, Care and Protection of Child Rule, so and so, provide that for the determination of victim in relation of offense against children under section under the Act, the same procedure mandate for the board and the committee under section 94 of the Act. Here again, victim has been reiterated, madam. Now 11. On combined reading of the provision referred to above, this court is of the considered view that the special court is duty bound to determine the age of either the accused or the victim if the dispute is brought before the court. In the present case, the learned special judge Pokso Bomdila appear to have taken a view which is contrary to the provision of law referred to herein above. 12. Since the age of the victim is relevant for the purpose of jurisdiction, it is incumbent on the part of the learned special judge Pokso Bomdila to determine it first, as same will have bearing on the trial of the offense touching the root of the jurisdiction. In view of the above, the impugn order dated so and so interfere with. Consequently, the order dated so and so passed by the special judge Pokso Bomdila is set aside. The learned special judge is directed to determine the age of the victim by following the due procedure and proceed with the matter as case may be permissible under the law.
Now, here is a case where we do not know whether this was disposed of on 22 or not.
My lord, then my lord may come. Now, my lord, the second judgment will be clarified. In the same, my lord, same proceeding, in the same order, the coordinate bench has again reiterated the judgment of this, the coordinate bench.
This
and has
different case or same case?
Yes, same case, my lord. Now, my lord, may kindly come.
Case, this came after, this was, by this order, it was not disposed of.
Note, my lord, the special court has not complied with the order of the Honorable High Court.
Thereafter, they have filed another.
Yes, my lord. My lord, now may kindly come to para 7 directly, my lord.
Yes.
I have perused the orders. Both the orders are fixed for age determination of victim as well as for final argument. Now here, madam, as well as for final argument. The trial court is directed to comply with the order dated 16/6/2023. The earlier I have already read out, madam. Passed by this court in connection with criminal revision petition number 12 of 23 and determine the age of the victim as per the law before final hearing of the argument. The proceeding of the POCSO case number so and so shall continue and the trial court is disposed of the matter of the age determining within 1 month. In term of the above observation, the petition is disposed of. And then, my lord, the age was determined. Age was determined, then final hearing was made and he was convicted. He was...
that is why I'm saying. So last order,
22.
whether determined.
Yes, my lord. 22.
If it was disposed of, rejecting, whatever may be.
Yes, my lord.
They need to challenge.
Yes, my lord. According to me, my lord, their application is still pending. Okay. According to me, my lord, my understanding. Your lordship.
No, understanding will not.
No, my lord, the record, if we go to the record, my lord, here on 22/4/2025, they file an application for determination of age. That is the misapplication number 122 of 25. On, my lord, 12/6/2025, on paragraph 2, my lord, the court give cognizance to that application and has noted that sin miscase number 122 of 25 filed by the Learned Defense Council under subsection 2 of 34 of POCSO Act praying for determination of age. And or at last, my lord, what court has directed? Court has directed the prosecution to produce class 12 certificate.
Yes.
And the date was fixed on 1/7/2025. Now, on 1/7/2025, my lord, the class 10 certificate was taken on record.
Yes.
And then matter was fixed on 22/8/2025 because on that particular day, 1/7/2025, nothing is done.
So it was taken on record.
Yes, it was only taken on record.
Then on
22/8/2025. Yes, it's supposed to pass or given them the opportunity for adducing evidence to rebut the same. But whether that was done or not, that is now in the grave because that is not on the record. So for that record has to be called for, my lord. Especially this,
my lord, appreciate, but on 22, my lord, matter was fixed for final hearing. As I submitted, the previous council, he didn't take up the matter. Another council was there.
What is the problem with accused? You have changed the previous council also? And then at the last moment raised this.
No.
Causing trouble to the trial court.
No. That, my lord, before changing of that also, my lord, these,
You have a right, of course, but
The
then you see, that
applications were-
exercise of right
no, my lord,
should also be on time.
on 22, 8, 2025 also, the missed case were not listed, man. Only the main case was listed. And it was for final argument. Just because a new counsel has come, he prayed for the matter may be urgent just because he will take time to argue the matter, man. That was the only proceeding that held on 22, man. That's why, man, we have filed an application seeking the certified copy of the proceeding order passed on 22nd August, man. That has not been provided to us till date.
My lord, since the 313 everything is done, now, my lord, what my humble prayer would be, my lord, the call for the scanned copy of the record, my lord, we have to look into whether the age was determined or not.
Yes.
And your
that
lordship,
is not-
now the accused is already
If
outside.
any order passed on 22.
Yes,
that need to
and
be
later
challenged.
on also, my lord.
That need to be challenged.
But
Yes.
two orders, man.
If you're right.
We have not got two orders, man. 22nd 8 2021 and 16/9 2025. Two orders.
22nd
22nd 22 8 2025
and
16/9 2025.
okay, it was fixed on 16/9 also.
Yes.
That order is also not here.
Yes. We have applied for that also. That also we have not been furnished, man. The
Some order was passed on 16/9 also.
Madam, we presume that
Then you see,
because
you are
the-
coming.
no order
Blindly
was
you are coming.
no order was passed in the open court. Now we have to presume something was passed, madam, by the presiding officer. We don't know what order has been passed. And we applied for certified copy. It's not that we didn't apply. Therefore, my humble prayer, madam, at this stage only is
What was the first order
My lord,
where you just now read
12,
some order? Yeah,
12 6
12
2025.
just prior to 1/7.
Yes,
Yes, madam.
12 6 2025.
page 91, my lord. NXR 11.
The order itself is clear, madam. It
No,
was not been.
12/6.
Yes.
Yes, 12, 6, then 1725.
Okay, so these two orders are not available.
This two order is here, but after that, no order is the part of the record.
Now, on 16/9/2025, it is fixed for judgment on when tomorrow, day after tomorrow, Monday.
The fixed, it was fixed, the April is fixed on 1/7/2025 for producing original certificate. Of
No, no, no. On on which date the judgment is fixed?
22nd August.
No,
Monday.
no,
22nd August.
no,
was
no, no.
fixed.
According to you, it
for
is going
final
to be-
argument.
or it is going to be listed on
It was listed on 16 month.
16 after 16. The last
Now it will be in 22nd Monday, madam.
22nd September.
22nd 9.
Yes,
Yes, ma'am.
Okay. So how do you come to know from this?
yes, ma'am.
Okay, so in this 22/8/25 and 16/9/2025, your advocates were not present.
No,
The accused were
we
not
were present, my lord.
Okay, what was the order
They
you said
pre-
in
present
16
this-
16/9/2025?
My lord, so 22nd we sought adjournment, advocate must sought
Okay, on
adjournment.
16/9,
69 also, madam.
so that means the order of
No, no.
1/7/2025.
Lordship is already there, my lord. The 69, I have just. Lordship will kindly see, I have annexed the cost list I have shown you, Lordship, but item 6, it is page 26, my lord. Here the,
Page 26?
yes, ma'am. Serial number 6, page 26. Here the criminal misapplication 197/2025 was listed.
What order
And
was
this-
passed?
This
This is for motion.
we have argued for recalling of the witnesses.
And what order was passed?
No, that's why we didn't get the copy. We have applied for, but we didn't get the copy. What order?
No
has been-
order was passed in open court.
No.
See, this is blind shot.
Record is.
No,
record will be
no, my
recorded.
lord, that's our councils were there, my lord. They argued the matter also.
In that case, my lord may fix a short date, my lord, and call for the record, my lord.
Argued the matter also, my lord, on that day, 16/9.
It is from the session court only, my lord, UPI.
Already argue the matter, argued on.
On the miss case, because miss case,
See, already argued. Naturally, some order must have passed.
For recalling of.
my lord, kindly appreciate, my lord. In 6/9, this is not for determination of age, my lord. This application was for recalling of the witnesses.
So that is on assumption that your petition was allowed, isn't it? Recalling of the witnesses means?
My lord, we didn't get the copy, certified copy of the
No,
order.
that is why I'm saying.
No, my lord, that is not.
But then your prayer is with the assumption that your petition was allowed.
No, we don't know, my lord. It might have been allowed, it might have been, my lord, rejected also.
You argued on for recalling of the witness
Yes, my lord.
to prove the age or disprove the age of the victim.
No, as a witnesses, not for the determination of age. This
Okay,
was
not
for,
for determination.
yeah, no, for recalling. No, we didn't get the copy, my lord. So we don't know, my lord. That is, anyhow, that is different matter, my lord. The recalling of, that would be a different matter.
Only because you filed just one day before the judgment, this petition.
No, but in April, we have filed for determination of age, my lord.
Now, why you had to file today,
My lord?
because this was before judgment.
Now, my lord, appreciate, my lord, no order has been passed in the miss case, my lord. How?
Can we call the record for Saturday?
No,
So
my
that,
lord.
to pass order on Monday, isn't it?
My lord,
See,
my lord.
why you should target the last date?
No, my lord, kindly appreciate, my lord. Because the judgment has been fixed on 22nd. Our petitions has been not been disposed of, my lord.
Okay.
Therefore, we had to come, my lord.
Hard, Mr. B. Dapo.
My lord, what we are praying, my lord, notice may be issued at this stage, my lord, and the judgment may be stayed, my lord. That's all. my lord.
Counsel for
Records may be called.
the petitioner. Para. So many dates. The petitioner, but also hard, Mr. An additional PP for the state respondent. You have made party to the
Yes, my lord.
victim also.
Yes. Notice has to be issued them also.
Who is this respondent number 2?
My lord.
Is informant. Respondent number 2 is informant. The the petitioner preferred this application
My lord, the respondent 2 is the informant.
under section 442 of the BNSS 2023. Excelling the legality, propriety, and correctness of the impugned order DP 01/07/2025. Passed by the Learned Special Judge POXO, UPIA, in criminal miscellaneous application number 122/2025 in POXO case number 26/2019, arising out of women PS case number 17/2019, whereby the Learned Court failed to refuse to fail to refuse to determine. Fail to refuse.
Refuse to
Fail,
determine.
stop. Refuse to, okay, not fail, refuse to determine the age of the
Victim.
alleged victim. Stop. Para. The contention of the petitioner is that despite of the clear mandate under section, where have you stated the section?
34 first.
Section 34.
2 of the POCSO Act. to a POCSO.
34-2.
Read
The 34 strong within bracket 2 POCSO Act, comma section 94 of JJ Act and Rule 54 stroke 18. Sorry, Rule 54 within bracket 18 bracket close within bracket Roman 4 I 4 of JJ rules 2016. 16. To determine the age of the victim before proceeding further in the further in the trial. Where is the reliance? So this is the reliance is produced by the.
I produced first, but I also have both of the judgment.
Okay.
Before me, my brother produced. Otherwise, I.
Because on those case, my lord, I appeared actually.
Okay.
Actually, I appeared this way.
I wanted to.
Okay, reliance is placed.
Vishpal Singh Solanki and my lord.
Okay, on the decision. Of this. No, the first one, no?
Yes, my lord. Pitam Lamio.
Okay.
Vishpal Solanki.
Okay. On the decision of the Honorable Supreme Court in Vishpal Singh Solanki versus State of Uttar Pradesh and others, reported in 2022 8 SCC 602. Which para you said?
My brother.
Sir,
33.
My lord, if it is SCC, then 33.
33. 33.3, no?
Yes.
Within bracket, para 33.3. And which one? Pitam Lamnio.
Lamnio versus State of
Okay.
18.
Semicolon, Pitam Lamnio versus State of AP. Reported. This is reported.
Yes, my lord. It's
In
reported in
2023 0 Supreme within bracket Gau
GAU.
bracket clause 766. That will do.
Yes, my lord, that will do. And your lordship may kindly also reflect the criminal revision petition number also. That will
And
be bracket.
within bracket
Criminal revision petition number
petition number
12 of
15.
my lord 12.
12.
Yes, my 15 is the second one. Actually, my lord, just
No,
for easy reference, my lord.
Okay.
It's
No, this is
12 of 23, the first one.
12.
12 of 23, my lord.
Okay.
The
So
Supreme.
this is okay.
And second one is 15.
No. Then within bracket,
Okay.
Criminal revision petition number 12 of 2023 and
Yes.
This also?
Yes, my lord.
Criminal revision petition number 15 of 2023.
Yes.
Stop. Okay, in view of the above submission, this court finds substance in submission that age determination of victim is, what do you say, foundation?
Yes.
Victim, the foundation fact for the applicability of the provision of POCSO Act,
As well as the jurisdiction of the court.
as well as the jurisdiction of the court, comma, and failure to undertake the same would result in prejudice,
Yes.
in prejudice and miscarriage of justice. Stop on para. Accordingly, issue notice returnable by issue notice.
Issue notice to respondent number,
Call for the
scan copy
scan copy of the
TCR, my lord.
trial court record. Stop. In
TCR.
the meantime, comma, and until the next day, there shall be a stay in the pronouncement of judgment.
Yes, ma'am, that's all.
My lord, maybe proceeding / pronouncement, because we don't know exactly what is the status, because this case seems to be pending.
Proceeding, supposing, we do not know.
Yes, exactly.
What order was passed? Proceeding, how do we?
No, but I will only.
Only pronouncement of judgment.
Okay, my lord.
Proceeding, supposing if they have already passed order, this will be C.
Okay.
Then he will be liable for.
Yes.
Okay. Yes, absolutely.
Like 22 of 8/2025, madam. If any order is passed, madam, then our matter might become infractions also. madam.
Yeah, that is why I'm saying.
Yes, ma'am.
You are coming blindly, you are.
Yeah, that will become infraction. The
And
matter will
then-
become infraction, yes.
Then,
Then judgment only, yes, sir.
Since, just a minute, huh? In the meantime, okay. Pronouncement of judgment. huh?
Yes.
In what is the case?
Women,
Judgment in what case? Where is the number?
women.
No, session case.
Yes.
So POCSO case.
POCSO case number 26 of 2019.
In,
POCSO case number 26, 2019 in women.
okay, in POCSO case number 26, 2019.
In women PS case number 17 of
In
2019.
women PS case number 17, 2019.
Yes, madam.
Do we need to mention that because this order is passed since we do not have the
Yes, prima facie case, my lord, they made up the case, but however, your lord,
the record of the
Yeah.
order passed on 22/8 and 25.
yes, specifically that may be mentioned, my lord, two order. But a TCR is called for, no doubt, my lord, but specifically the two dates order may kindly be called for, my specifically.
Okay, TCR, huh? Well, in the TCR, call for the TCR, including the order passed on 22/8/2025 and 16/9/2025.
Yes.
Yes, madam. That will suffice, madam.
Much obliged, madam. I appreciate, madam. I know, madam.
Don't come in the last. See, this generally such application, such order have been in the trial court also.
Yes, madam.
So this actually, here see what the court says, deliberately you are coming in the last moment.
Yes.
Despite of knowing that, and then you wanted to take advantage of the court's timing, and then because court normally take care of the right and fundamental right, especially.
Yes.
The liberty of the person.
I appreciate that, madam. Now, madam, your lordship, what happened, madam? We filed the application in April 2025, madam. That has not been disposed. Suddenly the we see on portal that the judgment is on 22nd. We were terrified, my lord. That's why we had to rush to this all.
Anyway,
Good, my lord. I appreciate, my lord. Much obliged.
List this matter on, when we say, list
Return-
this matter
return-
again on,
Madam, returnable after 2 weeks.
2 weeks.
2 weeks,
after
madam.
list this matter on, okay,
After 2 weeks.
after 2 weeks.
Yes.
It will be automatically listed
We'll,
after vacation only,
my
madam.
lord,
That will be
we'll
immediately
take steps,
after-
my lord.
This is matter immediately after the vacation.
After vacation, yes, madam.
Steps.
Immediately after the entering puja vacation.
Yes, your lordship.
Okay.
Yes, your lordship.
Steps.
Okay,
Obliged.
no, steps, have I said? The issue notice, the
Petitioner.
petitioner shall take steps for notice upon the respondent by a registered post with AD as well as by usual process. Or no, it's by.
Yes, madam, it has to
it's
be
draw.
taken through us.
Okay,
Victim, my lord,
then,
we can-
it's, be taken through
Office of
the-
PP, madam.
through the office of PP to be routed through office of
Yes,
PP.
yes, my lord.
Through the
Jurisdictional,
through the jurisdictional police station. Okay,
yes, madam, that will suffice.
Much obliged.
within 4 days.
Yes.
Yes, madam. Yes.
Okay.
Obliged, madam.
4 days, of course, Saturday, Sunday. all that.
No, that will exclude, that is,
that
the-
will
okay, within 5 days. Okay.
Much.